Yes. Well,
With due permission, my lord, I'm mentioning for inclusion in the list.
what is the matter?
It's motion matter. That's it,
Assign to her. Assign to me.
Yes.
Assign to me. I don't have regular determination. Please check up. Mention on the next day. Check up and mention. Call on.
This is the order passed in my application filed under Section 36 of the Arbitration Act.
Lord, my learned friend wants return of the bank guarantee and and the security furnished.
There.
My lord, only one request. My lord, the appeal has been filed. The stay application is before the land division bench. My lord, it was yesterday, could not be taken up. It is also there today. If your lordship deposit, my lord, till next Friday, my lord, we'll know what happens. Either we get a stay or we don't get a stay.
Mr. Vasu, we will give you liberty to file an application before the or move make this prayer before the division. So appeal has already been filed. A stay has been filed.
Yes, but
I mean, if you pass an order now today and tomorrow it's stayed and then meaningless. I'll record that Mr. Shah's submission that an appeal has been filed and the stay has been it's on the board on the in the list.
yes, it is running in the list.
By the by a judgment of this court, comma, the award from which APCOM 381 of 2024 arose was set aside. Full stop. Accordingly, learned counsel appearing for the appellant therein, comma, which was successful in the appeal in the application under Section 34 of the Arbitration and Conciliation Act 1996, comma, seeks to withdraw the amount deposited in connection with the application under Section 36 within bracket 2 of the said Act in respect of the self-same award, comma, since the award has been set aside. So next para, learned senior counsel appearing for the respondent in the appeal submits that an appeal has already been filed against the judgment passed by this court under Section 34 and an application for stay is already on the board before the concerned court taking up the matter. Full stop, in view of the said stay application already being pending, comma, liberty is given to the appellant in APCOM 381 of 2024 appellant petitioner হবে ওগুলো appellant যেখানে বলেছি আমি petitioner in APCOM 381 of 2024 to renew the self-same prayer before the bench taking up the appeal under Section 37 of the 1996 Act against the judgment of this court. Because the stay application has already been filed. Look, and also I pass an order today and tomorrow it's stayed and
Yes. I will technically have to file a second appeal against that, but
I fully appreciate, and we will not do any. We've got crores of bank guarantees. We have not touched them. We are waiting for the stay application to be over.
so that will be easier for
This is not a cat and mouse game.
no.
Item numbers 2 to 5, my lord. On the last occasion, my lord, they had filed a supplementary affidavit. Application, I'm sorry, supplication for my lord, disclosing my lord, certain documents. My lord, after my lord, we had argued, but we had taken time to my lord, file a affidavit to that effect. My lord, that is still not ready because my lord, there is a. I'll tell you, lordship, my lord, because my lord, your lordship knows, my lord, this is a stray matter where my lord Narsil had my lord taken over my lord the management. So my lord, because of the change of management, a lot of my lord old documents which they have relied upon, which was there with the old management. So which is
How long
it's
do you
taking
take-
some time.
How long would you want?
So that not to avoid any embarrassment, if your lordship kindly gives me like 2 weeks time to come back. So
2 weeks thereafter, will reply.
Learned counsel appearing for the petitioner submits seeks an extension of the time for filing affidavit in opposition to the application filed by the respondent seeking disclosure of certain documents. Post of learned counsel for the petitioner submits that due to the change of management of the said of the petitioner, comma, the some time is required to trace out the relevant papers. Full stop, next para. In view of there being substance in such submission, comma, the time for filing affidavit in opposition to the application bearing, this is GA
So
one.
this is GA1.
GACOM 1 of 2025 is extended for a fortnight from date. Full stop. The matter shall next be listed on এই ক্যালেন্ডারটা ঠিক করে দাও, এরকম ভাবে রয়েছে আমি দেখতে পাচ্ছি না।
Lord,
এদিকে ঘুরে
after
চলে
4 weeks, it takes us to the 12th of December.
একটু দেখে নিতে
Lord,
হবে।
the week thereafter.
এখানটা দিয়ে দাও তাহলে, ওদিকে দিয়ে দিতে হবে, আজকে তো সিঙ্গেল, এখানটা দিয়ে দাও সাইড করে। On December 5, 2025. Till December 25, December 5, 2025, so reply if any shall be filed by December 12, 2025. The matter shall
Right,
be,
so 2 weeks, my lord, for
2 weeks is 5th December.
my lord, he saw 2 weeks,
Oh, I'm
takes it to
sorry.
the 28th.
Sorry, প্রথম ডেটটা হবে extended till November 28, 2025. Reply if any shall be filed by December 5, 2025, when the matter shall next be listed under the same heading. Give an advance copy.
Well,
Sorry,
it is
Lord.
2 weeks, my lord. December 5 takes us to the very next week, my lord. I was saying if it could
Yes,
be on the
reply.
12th. Well, they said these documents.
তাহলে রিপ্লাইটা যেটা December 5 যেটা বললাম সেটা December 12 বাকিটা এক।
Great.
বলে দিচ্ছি when the matter shall next be listed for.
Great.
Thank you.
My lord, appear for the respondent, my lord. I'm opposing the section 34 application. My lord, learned counsel, Mr. Pradeep Chindra, learned advocate, was
Yes, yes,
making,
he was there.
making submissions.
You are making submissions.
Here. Yes, Mr. Chindra was
For
making.
you, yes. Yes, Mr. Right. Yes, Mr. Please.
Just give me 1 minute.
Yes, please.
Yes. So, Manoj, we were just going through my first. I'll just recap quickly in 3 minutes as to what were the submissions earlier, and then I'll straight away start with the relevant submission that we have to start with today, Manoj.
Right.
So first and foremost, Manoj, of course, I stated that the award is marred by fraud for the reason that the presiding arbitrator couldn't have been in a capacity, couldn't have been in a mental and a physical capacity to
Yes.
write the award, to give the award. 10 years award, Manoj, 10 years of arbitration. He was hospitalized for 2 particular periods, Manoj, and immediately just before the pronouncement of the award, he was discharged 24 hours before from the hospital. That was my first submission. Therefore, I was stating that the horse of all merits or anything else, it's an award which has been signed just on a dotted line, Manoj, where there is no application of mind by the honorable presiding arbitrator, and he couldn't have been in a capacity, and the way it has been portrayed is that as if he is writing the award.
Yes.
It's not as if it's a joint deliberation. That was my first submission. I won't repeat everything, Manoj. The second point was violation of section 31(2) of the Arbitration Act, wherein the statute mandates that one must have specifically the reason, either the sign of all the 3 arbitrators or the reason for non-signing in the award.
Yes.
I had shown that there is no reason stated either outset at the award or also either in the award or also otherwise, Manoj. There is no email, nothing which has come. In fact, to the contrary, it has been stated in the minority award that the minority arbitrator was just informed and nothing else. That was my point number 2, Manoj. Then these were points on the, so to say, demurrer, Manoj.
Yes.
Then on the merits of the matter, I had first argued that the arbitral award is contrary to the specific terms of the contract. In as much as I had stated that there is a specific guarantee clause. The guarantee clause says that either the guarantee will be valid for the generator set, either for 18 months from the date of commissioning or 24 months from the last date of supply. It was established from the record that the last date of supply was 28th of December 2006. Therefore, the guarantee was valid only until December of 2008, whereas this machine was rejected on 27th of July 2009. So it was beyond the guarantee period, so to say, Malaj. And once I'll come to law, Malaj, I will show from the Sale of Goods Act that when an express guarantee is provided, which is contrary to any implied guarantee, the express guarantee prevails.
All right.
That's going to be my legal submission, which I'll get to in terms of law, Malaj, a little later. So it could not have been the case. The argument is, therefore, it could not have been the case beyond the guarantee clause that the machine was defective per se. The guarantee was only valid for a period of 24 months. Otherwise, what's the point of giving an express guarantee? Malaj?
Yes.
That's the first point on merits, Malaj. I'm not going into details. I'm just recapping. Malaj. Then an argument, Malaj, was raised that majority award has actually rewritten the contract between the parties. Malaj remembers the aspect of the scope of commissioning and the whole argument regarding commissioning and non-commissioning. The argument of the justification of the majority award is that because there were breaks in operation, therefore it could have never been commissioned. There was no successful commissioning per se. Whereas we are stating, Malaj, that this aspect of continuous operation was never mentioned in the award, was never mentioned in the contract per se. This aspect of continuity is something that has been read into it and that has been actually added in terms of clause, which is contrary to the plain and fundamental meaning of clause 14, Malaj, which is the guarantee clause. This was my second argument on merits, Malaj.
Yes.
I'm not going into details.
No.
Then the third point, Malaj, was on merits that given everything against me, let's assume everything to be against me, the extinction price is something that has not been established on record. The claimant, who are respondents herein, have not been able to justify an amount of 1,33,50,000 rupees on the basis of anything that is on record. The plain invoice as far as the turbine is concerned is only of 40 lakh rupees. They state in their rejoinder that this is turbine in addition to some ancillary other products. They don't define what is the ancillary product. They are questioned specifically. They don't say anything as far as the ancillary product is concerned. Neither it is clear from the record. One cannot infer on the basis of the material that's on record that on what basis they have reached to this value. That was the third point, Malaj. We were on the fourth point, Malaj, on merits. As to, given everything against me, the award pertaining, the majority amount of award that has been passed against me is regarding the expenses pertaining to electricity consumption, which according to the claimant has been taken by Damodar Valley Corporation, and some part of it, according to the claimant, has been generated in its own plant by using diesel generator sets. So therefore, some amount is pertaining to the diesel that has been consumed. That is where, Malaj, we were in terms of, and the discrepancy there. And my legal argument is that this is a case of actually no evidence pertaining to this aspect. Because if you take that evidence at any which way, and it had fallen from this honorable court, that there was no comparison of the amount that they could have, that the loss between the amount of electricity that they generated by using alternate sources and the amount which on the basis of which they could have generated electricity by using the captive power plant. That sort of, Malaj, comparison between the two prices is not there. What instead is there is just the bills of DVC, and there is a ledger pertaining to diesel, for which they were particularly questioned. So I'm just going to get to that, Malaj, on the majority award. please first have a look at the majority award in volume in the application file, in the stay application file, and page 122 to 129. Manoj, may please have a look at that first.
Yes. পরে ভলিউমটা হাতের কাছে রেখে দাও। Yes, please, Mr. Chandra.
Malak. So the majority award, Manoj, starts at 120. It starts at page 20.
Yes.
And we are at page 125. Internal page 102, Manoj. Internal typed page 102 and handwritten page 125 on top.
102, give me half a second. ভুল দিয়েছে ওরা। 102 to tally করছি। এটা কি award? এটা স্টেটমেন্ট অফ ক্লেম দিয়েছে, অন্য কিছু দিয়েছে।
This is the stay application file, Manoj.
অ্যাপ্লিকেশনের যেটা
Yeah.
অ্যাওয়ার্ডটা অ্যাপ্লিকেশন আছে। Yes, please, Mr. Chandra.
Malak. At page 125.
Got it. Yes.
Yes. So I'm reading Malaj. Malaj had already read this part about commissioning and decommissioning. This is what follows from it, Malaj. I'm reading at the bottom.
Yes.
Of 125. There is a major claim by the claimant.
Yes.
Yes. There is a major claim made by the claimant in this proceeding that is on account of increased cost of electrical energy and extra expenditure. This claim has been narrated in paragraph 48 of the statement of claim. The detailed evidence in support of such claims have been given by the claimant's witness CW1 in paras 55 and 56 of its affidavit of evidence. This claim, according to the claimant, has arisen by reason of failure of the turbine to perform, which had prevented the claimant to utilize of captive power plant till the new turbine was installed, which resulted sufferance of loss and damages by the claimant. In order to prevent sufferance of high electricity and fuel charges, the instant contract was entered into to purchase the said TG set. The said TG set, which was supplied by the respondent, ultimately did not perform. The claimant could not get benefit of the said set and consequently went on incurring electrical energy for higher amount. The schedule containing the details of the increased cost of electrical energy has been produced by the claimant and has been exhibited as Exhibit 107. The claimant had also produced the bills raised by DVC, from whom the claimant used to get electrical energy, at Exhibit 114. I will show Malaj each of these exhibits and how in the evidence they have not been backed by the witnesses, especially Exhibit 107 and 108. I'll come to that. Calculating in details about the extra expenditure of high safety oil has been disclosed in the statement of claim and has been marked as Exhibit 108. The claimant has also referred to the document being ledger showing the expenses incurred on such account being Exhibit 115. The claimant's case is that high expenditure on account of electrical energy could be reduced only after installation of new machine after 8th of June 2010 from 9.43 per kilowatt to 2.75 per kilowatt. The evidence is thus, in this regard, of CW1 and CW2 was placed. It is evident from the record that no cross-examination was made by the respondent on this document. Malaj may mark this. This is completely incorrect. This aspect or this finding of the Honorable Tribunal is contrary to the record, that there is no cross-examination made by the respondent on this aspect. I will show Malaj how. According to the claimant, According to the claimant, that claim of damages on this account was directly a result of failure of the respondent's turbine. Against this claim, the respondent's contention was that annexing DVC bills and the ledger account being Exhibit 107 and 108 are meaningless. The respondent's contention was that the claimant had not proved the said claim of rupees 7.56 crores. According to the respondent, there is no proof of payment to DVC as allegedly made by the claimant. According to the respondent, the said claim of the claimant on account of increased cost of electrical energy is baseless. Considering the above contention and counter contention of the parties with regard to the claim on account of increased cost of electrical energy, and after considering the documents relied on and the evidence led in respect thereof, I come to the finding that since admittedly the said machine did not run satisfactorily after erection from 28 December 2006, naturally, the electricity could not be produced out of that, which was the main object of the claimant for entering into the said contract with the respondent. It is also to be considered that such electrical energy was required by the claimant not for distributing of the same to other consumers, but for its own use in its plant at Durgapur. Therefore, such energy was a most important factor to make the said unit of the claimant running continuously and with minimum cost. The claimant, however, has not made any claim for damages for it not being able to run the plant and consequent damages thereto. It has claimed only the money which it had incurred to make its unit running by paying extra and or more expenditure to buy electricity from DVC and an account of cost of diesel. I have already held above that the machine had failed to perform according to the contract, and accordingly, the claimant has become entitled to get the extinction of price. If that becomes the position, in fact and law, then automatically the question would arise as to whether by reason of such non-performance of the machine supplied by the respondent, the claimant in addition to extinction of price would be entitled to claim any damages from the respondent. Here, in the instant case, the damages as claimed not in the nature of loss of profit, but on account of increasing extra expense for buying energy, which the claimant could have avoided had the machine run effectively and in accordance with the parameters contained in the contract. I accordingly hold that the claimant would become entitled to the claim of damages by way of increased cost of electrical energy as claimed in prayer D. In this connection, I may refer to the claimant's contention that the claimant could ascertain the extra cost which has incurred only after installation of the new turbine on 8th of January 2010. According to the claimant, such money could have been reduced from 9.43 per kilowatt to 2.757 per kilowatt. If I accept this figure as given by the claimant, then I must come to the conclusion that if the TG set which was supplied by the respondent could function properly and in accordance with the contract, the claimant could have incurred expenses on account of electrical energy and at a reduced price. Malaj, may underline this portion for the reason specific question was asked to the witness, stating that on what basis he is saying that. The witness says, I don't know. He cannot answer. I will show that to the Honorable Court. Moving ahead, Malaj. As mentioned above, the claimant.
Yes.
Yes, Malaj, just one. Sorry, I can't see that. Yes. Well, as mentioned above, the claimant in support of its claim on account of extra cost incurred for energy and diesel has exhibited 3 documents, being Exhibit 107, 108 and 115, Annexure KLMN of the Statement of Claim, showing details of such expenditure. The Annexure L indicates the cost of minimum contract demand with the DVC was rupees 4,67,20. Therefore, if the total consumption of electricity is calculated from the cost of minimum contract demand, it would appear that there was extra expense incurred by the claimant. Simultaneously, the claimant had also given details of the expenses incurred on account of diesel oil in running generator set. I do not find that there is any cross-examination effectively made by the respondent counsel to the claimant's witness on such account. This is false, Malaj, and I'll show. Malaj may underline that this is contrary to the record. Without having any contra evidence from the respondent against such claim of the claimant on amount of extra expense, I accept the said claim of the claimant of rupees 56,75,686 as mentioned in prayer C and the statement of claim and pass an award of such amount in its favor as against the respondent. Malaj may now please straight away come to page 131.
Yes.
And then Malaj may please see, I am referring to the table herein.
Yes.
It states what has been granted on what count.
Right.
I am on entry number 4, serial number 4.
Yes.
Where on account of increased cost of electrical energy and extra expenditure of high cost speed of oil incurred by the claimant, 7 crore 56 lakhs asked for, Malaj, and 7 crore 56 lakhs 75,000 granted. The first one, the first claim is in relation to extinction of price 133.50, which I have referred to, Malaj. in which I have stated that there is no evidence on record for that.
Hmm.
The second claim, they did not get anything. The third claim is an account of repairs and maintenance incurred by the claimant.
Hmm.
Here, Malaj, the defense is very simple, that these repairs and maintenance were incurred during the time of guarantee. Under the clause of guarantee, Malaj, we were actually under a obligation to correct everything, whichever is wrong, without payment of any money.
Hmm.
But the amounts which were raised were paid by them without demur, Malaj. So this is a case really to say that this is not something which was covered under the guarantee and which was agreed by the parties. In other words, acquiesced.
Hmm.
They acquiesced to pay me the money on this aspect. So this could not have been paid. And in any case, Malaj, if the first part goes, this cannot be awarded in any case.
Hmm.
And the fourth claim being the cost of increased electrical charges. This is now what I will take my lords to in terms of where and what has been stated by the witnesses, and what is my cross-examination, what is the effect of that. And so much so, Malaj, I'm conscious of the fact that we are in a 34. I'm conscious of the fact that this honorable court, of course, if it's a plausible or if a possible interpretation, the honorable court will not get into it, but I am testing it from a highest standard, from a highest litmus, so to say, that this is no evidence per se in law, irrespective of the application of the sections of the Evidence Act. I am aware that under Section 19 of the Arbitration Act, Evidence Act per se doesn't apply, but the principles of basic principles of evidence would apply even to an arbitration matter. Manoj, may now please see. Manoj, may please see the SOC in volume 4. Volume 4 of the application file.
Yes.
Starts at 495. The relevant portion, Malaj.
Yes.
It starts at 495.
Hmm.
The relevant portion is at page 535.
No, is this in the main?
It's in the AP file, Malaj. AP number dash.
So in the main matter.
Section 34.
It's in the section 34. Yes, Malaj. AP in the GA.
তাই ভাবছিলাম কেন ওখানে রয়েছে ঠিক আছে না না এটা তো জি এটাই দেখিনি 535 আছে কিনা এটা সেম মনে হচ্ছে সেম মনে হচ্ছে এইটার
Volume 4.
It's on the top of it, Malaj. That application is written on the top of the
Yes.
on the index page.
No, no, it doesn't. You're right.
একটু পুরনো যেটা সেটা হচ্ছে এটা
Sorry, Malaj, there are too many volumes and
No,
they are divided into, we should have been more sort of careful.
35 যেটা নয় এটা সাপ্লিমেন্টারি এফিডেভিট দিয়েছো
This is supplementary, Malaj. This is different. This is different. This is
সাপ্লিমেন্টারি এফিডেভিট লেখা রয়েছে তো এখানে
it's the 12 volume, Malaj. It's the big 12 volume
মেইনটা যেটা
4 to 553.
in the main petition, in the section 34.
Is there a paragraph 48 in that page?
Yes, Manoj, I'm referring to paragraph 40.
Please
I'm
come.
referring to para 48.
Got it. Yes. Thank you.
It starts, Manoj, at just for completion, it starts at page 495.
Right.
The relevant portion is at 548. Yes.
Yes.
Manoj, may now please see, this is what the evidence of the witness is. Although even after taking into account the extensions granted to the respondent and saving the cost should have been available to the claimant from 28th December by reason of the respondent's failure to duly commission the turbo generator set and further the reason of the inherent defects in its turbine requiring the same to be replaced, the claimant could avail of such savings in the costs only on and from 8th of January 2010. As a consequence, by reason of the breaches and latches of the respondent, including breach of the fundamental conditions of supply and of the warranty, particularly on the turbine, the claimant suffered loss and damage on account of increased cost of electrical energy. Now they are giving the breakup, Malaj, of 7.57 of electrical energy is rupees 2 crore 64 lakh 16,000 and extra expenditure on high speed diesel of rupees 4 lakh 92,59,119, aggregating to 7 crore 56 lakhs for which it is entitled to be compensated by the respondent and claims the same. A schedule containing the particulars of the computation of such loss on account of increased cost of the electrical energy is annexed hereto and marked as Annexure L, and further schedule containing cost of extra expenditure on high-speed diesel from the period between January 7 till December 9 is annexed hereto and marked as Annexure M. Now, please have a look at these documents, Manoj. Annexure L and Annexure M. What are they? And what is it that they state? Please have a look at volume number 6 of the same continuation, Manoj. Volume 6, page 796.
Mr. Chinda, can you just tell us just from your notes what other volumes you'll be referring to after this?
Yes, Manoj. So,
one or two volumes so that they can keep it ready.
Yes, Manoj. Yes. So, in fact, all my volumes are
from AP.
Yes, from the AP. Yes.
আচ্ছা এবার AP ভলিউম গুলো একটা জায়গায় রাখেন।
AP Malaj may keep handy and supplementary affidavit in supplementary affidavit volume number 1 and volume 3 of the supplementary affidavit.
Thank you very much. Supply 1 or 3 side correct. Thank you. Please continue. Yes.
Malaj. At 796.
796. Yes. That is L.
Yes. So this is what was referred to as Annexure L. Malaj can mark it on this, that this is also referred to, or this is the exhibit, which is at page 681 of the supplementary affidavit of volume 5. I'm not taking Malaj to that, but this is the same affidavit. This is the same exhibit. It's not different, but just for completion.
Yes.
If Malaj want to tomorrow see it.
Right.
I'm not taking Malaj to the relevant portion.
Yes.
Annexure L is this, and Malaj Annexure M is on the next page, which is the schedule. The one at Annexure M is at page 682. It is exhibited at page 682, volume 5 of the supplementary affidavit. Malaj may make a note if required. But I'm not referring and cross-referring because there is no point. The content is the same.
Yes.
So Malaj may please look at Annexure L. Annexure L is allegedly the consumption of electricity from the DVC. And Malaj may please see, they start from January of 2006 up until December of 2010. That's what they are referring to. So this is the entire amount that they have asked from the DVC. There are DVC electricity bills also, Malaj. I'll come to that also. The substantiation of that is in those. That's how they substantiate it. This is exhibited by one particular witness. Those are exhibited by another witness.
All right.
Now, Malaj, may please see exhibited at so and so. Yes. Now, Malaj, may please refer to volume number 7. I am first coming to the substantiation of Annexure L in volume 7.
Yes.
In volume 7, Malaj, it's page number 970.
Yes, 970.
Yes. Now, Malaj, may please have a look at 970. And I don't know how clear it is before the Honorable Court.
More or less legible.
Yes, yes. So it is Exhibit 114 written, and it is also written documents in connection with annexure L.
Yes, exactly.
Right. So Malaj may just see, I will just show one document, and Malaj may take it that it is same for all.
Similar, yes.
Yes. Malaj may see the amount of gross bill amount,
Yes.
which is from bottom, it is the second column.
Yes.
Second row.
Circled it, so someone
Yes.
circled it, so it's easier for
Yes, yes.
34, 35, 317.
Yes, Malaj. And Malaj may please see that in annexure L, there is an entry of January 34, 35, 317.
Yes, corresponding.
So, so in other words, their claim is whatever we have consumed for electricity from the Damodar Valley Corporation, that entire money is chargeable to you. That is what their stand is, Malaj. Now, Malaj, may please see the cross-examination of this relevant witness who refers to this. Malaj, may please have a look at volume number 10.
Yes.
Malaj, may refer to, I'll first take Malaj to the specific question and then to what his view is on the other points. Malaj, may have a look at straight away 1377.
Yes, please. 3077.
And the top question, Malaj, 795 and 796.
Yes.
So this is referred to as Exhibit 107, Malaj, Annexure L. And this, a question is put to the witness, kindly take Exhibit 107 and tell the learned tribunal as to what this document is about.
Now I remember all his answers are the commercial.
Yes, Malaj. So all his answers are that this is a commercial matter and I cannot answer. So he backs out from this document, the primary document of Annexure L. So if he has backed out from the primary document, Malaj, it really doesn't matter what the next other documents are. But coming to even the DVC, Damodar Valley Corporation bills, it cannot be the case of the other party that whatever they have consumed is going to be palmed off to me in the absence of the CPP. So the CPP was functioning, Malaj. They had the minimum capacity and the maximum capacity from Damodar Valley Corporation. Any running industrial unit would not run without an electrical connection, Malaj, irrespective whether you have the CPP or you don't. So it cannot in the measure of, it cannot in terms of law be a measure of damages per se. This is too remote.
It is not their case that this turbine, the defective, so-called defective turbine would take care of their entire needs.
No, Malaj. So they, in fact, and I'll show, yes, and I'll show that question, and I'll show those questions also. The questions were put to them that even during 8, 9 and later, from 10, 11, 11, 12, did you have the DVC connection? They said, yes, we had the connection.
Exactly, because that difference was never shown.
Absolutely, Malaj.
You were saddled with the entire cost.
Entire cost, Malaj. And more importantly, that can't be the measure. I mean, I can, of course, say to this Honorable Court that these are only bills of DVC. There is no proof of payment to the DVC and so on and so forth. But that's
probably the Section 34 also cannot
get into. Therefore, I don't want to.
Yes,
therefore, I don't want to make that submission.
Right.
So that is, Malaj. So therefore, Exhibit 107 and 114 do not establish any evidence per se. If a person who is giving a document, he backs out, Malaj, and he says, look, I don't know about this matter. To my mind, Malaj, that's the end of evidence on that aspect. Now, please see in this volume itself, Malaj, at page 12, and please have a look at just to substantiate 795 and 796, his answer consistently at page 1288 also for any commercial matter.
Yes, everything related to commercial.
Yes.
That was a common refrain in his commercial cross-examination.
Yes, Malaj. And Malaj, may please have a look at page 1295 for a minute.
1295, yes.
Yeah, same volume.
Same. Question 184 to 186 similar.
Yes, Malaj. In 188, I say yes, Malaj. So this is actually the evidence of just a minute. I'm just seeing. Yes. So he is actually specifically asked in 186. Sorry, in 188, that on what basis are you saying that this reduction of 9.43 and 2.57 per unit?
Hmm.
What do you say in that? He says, I will not be able to reply to this question, sir. So Malaj had read it in the affidavit of evidence, or sorry, in the claim, they had stated that the amount of electricity reduced from 9.43 to 2.57 per unit. But they have no backing to that, Malaj.
You seem to have you are having a kick out of it, because you actually ask him, is it not a commercial matter? So in question 184, whoever was cross-examining was having some fun. But an answer also
The
diligently.
gentle, yeah, he has answered also.
Yes, it is purely so he took
yes.
the bait.
So sorry. I was not
Anyway.
associated, Malaj, when this was going
No,
on.
somebody else must be, yes.
Yes. Now, Malaj, may please see
Yes.
that yes, and Malaj may take it that they always had the connection. In volume number 11 at 1423, it was specifically asked to them, question 260 to 264. Malaj, please have a look at volume 11 for a minute.
Yes.
And at page 1423, I'm sorry, it's not 1423, Malaj, it's
It must be some
it's 1425.
25 years.
Yes.
Yes.
Manoj may see that contemporaneous questions were asked from 260. Please refer to your answer at so-and-so. Did you reduce your demand for consumption of power from DVC around 1st of January 2008? So they say, I cannot tell this from my memory. I have to check. Kindly look at the documents that are available with you. He says it was 1250 kilowatts in January 2008, but I do not know when it has been reduced. Can you indicate to the tribunal the demand as on November 2007? He again says it's the same 1250 kilowatt.
So what happened on 1st January 2008? This was commission.
No, commissioning was Malaj 2006. So questions are being asked for the period of operation. Yes. For the period of operation from 2006 until 2009, when it was rejected.
Yes.
Specific questions are being put to him. Did you reduce? Did you give any application? Was it completely disconnected? What happened? So he says, please come to you have stated that you are meeting the demand for the balanced electricity about 1250 kilowatt from diesel generator set. Is that not correct? Then he says, what I said was whatever deficit the company was facing in consumption of electricity was covered by running the diesel generator set. You will agree with me, as you have deposed earlier, that it is cheaper to source your electricity from DVC as opposed to diesel generator set. He says yes. In accordance to page 78 of your evidence in chief, your demand and sourcing of power from DVC was 2500 kilowatt. Why did you rely upon the diesel generator set being more expensive option as opposed to available source of power of 2500 kilowatt from DVC? I have already said that we had to pay a minimum guarantee charge towards contract demand for whatever amount of electricity we have taken from DVC. When we got the supply of a turbine, they said that the turbine will run properly. Then we had decreased our contract with the DVC. Now it is not possible for us to increase and decrease the contract demand on a daily basis by the DVC. So what is being shown, Malaj, is to say that if the consumption from diesel was higher, there was no point for you to consume diesel. Rather, you should have taken DVCs and increased DVC. In other words, mitigation of loss is what is being pointed out, Malaj, here.
But they give some answer to that in the form of that.
Yes,
contract demand was reduced. They could not
reduce the quantity. Absolutely, they say that we wanted to reduce from 2500 to 1250, but it is not as if for 1250 can be palmed off to me. Is the question, Malaj?
Right.
In consonance with this, I could have been saddled with the difference between 25 to 1200, but not the entire. Is the point. Now, Malaj, may please have a look as to what is their basis for saddling me with the second portion of diesel. What is
Yes.
the what is the kind of evidence that they give? Malaj, please see volume 6 and volume 8. Malaj, take it volume 6 and volume 8. I am now going to refer to 108 and 115. We already have volume 6, Malaj. Volume 6, annexure L was open.
Yes, yes, yes.
I am referring to annexure M now in the same volume.
Yes, yes, right.
And volume 8
Hmm.
is when I will refer to what has been given.
Right. I have.
Now, volume Malaj, please see 797 volume 6, the table, and juxtapose this to page 1006 at volume 8.
Yes, yes.
Malaj, now see, please. Just see the plain. Let's first understand what the evidence is, Malaj, according to them. So 115, Malaj may have a look. This is a copy, and on top of it, Malaj, this is a copy of the ledger account that Neometallic maintains in its own ledger books. And then they say what have they purchased and from whom, what payment has followed, and so on and so forth. But this is just the ledger running from 1006 up until 1064.
Yes.
There is no document supporting this. Ultimately, it's an internal ledger. There is no bank account statement. There are no bills. There are no details. There is no pay order. There are no orders which have been placed on whoever. So this is the ledger, Malaj. This is the whole soul of the ledger on the basis of which 4.92 crores have been awarded. Now, please see, Malaj, the cross-examination. Malaj had noted that it is being asked, the honorable tribunal says that they have not been cross-examined on this basis. Now, Malaj, please see. At volume 10, page 1377, question number 797 and 798. Again, I'm referring to that same portion where he says, I can't.
Yes, yes.
I can't answer. And that is in relation to annexure M, Malaj. Annexure M also, which is exhibit 108 at page 797. He also says, sorry, it is a commercial document, I cannot answer.
All right.
Now, Malaj, please see. So therefore, again, the argument is where the primary document is result form and the rest of the documents are internal self-serving. That cannot be a measure of damages. And in any case, Malaj, specific question was put to the other witness at volume 11, page 1423.
The 11. এখানে আছে? আচ্ছা।
Yes. Page 1423.
Thank you.
Question 248 and 249. Malaj, may please see from 244 itself at page 1423.
Yes, please.
Now, Malaj, may see page 2, para 2, question number 244.
This is CW2 cross-examination.
This is CW2, Malaj. This is Ashok Kumar Agarwal.
Right.
There are two witnesses by them, Mr. Kesharwani and
Yes.
this is Ashok Kumar Agarwal. Kesharwani allegedly was a person who was the technical person and who was there until October of 2007, admittedly. He left in October 2007. That's why Malaj, he says post-October 2007, I can't answer anything. And in any case, this is a commercial matter and so on and so forth. This gentleman was, of course, with the company during the duration, but then again he says I'm a commercial guy, not a technical guy. So now please, in that light, Manoj, may please see question 244. Kindly tell the tribunal as to who has prepared the documents appearing in pages 105 to 165 of your affidavit of evidence. These are the ledgers, Manoj. He says these are printouts of different ledgers that are maintained by the accounts department of the company. I repeat the question, who prepared it? He says to the people in our accounts department. Now please see question number 248. I say, have you disclosed any supporting document to the entries in the so-called ledgers? I do not remember. I'll have to go through the records to answer this question. I suggest to you that there are no such supporting documents. He says, I do not agree. But they don't put any supporting documents post this questioning. When they are specifically asked for that, do you have any underlines? He says, I might have, the accounts department might have, but they don't substantiate it at all.
In the by way of substantiation, what sort of documents are you wanting? Receipts and all these things? Challans, receipts?
Only the factum. Number one, the factum that this was done and the factum that amount was paid.
What could have been produced by them? Receipts.
Receipts and bank balance and the
bank statements. Yes,
yes,
right.
Bank account statement would have been the rather more clearer.
Yes,
would have been the rather more clearer evidence, so to say. But internal ledgers self-serving could not have been, especially when I've cross-questioned them. Had I not questioned them, that's a separate issue, Malaj. And beyond this, there was no reason for me to probe. I would be helping them to bring evidence on record.
Exactly. Why should you elicit their answers?
Elicit their answer and to be more careful or ask them to produce something.
True.
If they thought, they could have produced it, but they did not.
That is what cross-examination is all about, actually.
Absolutely, Malaj. Absolutely.
Yes.
The art to know when to stop is perhaps rather more important.
Much.
than to know what to ask.
True. Very well. So no supporting documents.
Yes. So no supporting documents in any case. This is the second aspect of it, Malaj. Now, what is even more stark is when we cross-examine their witness on the point that, look, according to us, all this is bogus because in your own balance sheet for a relevant year of 8 and 9, you don't show any expenditure towards electricity or expenses. They don't have an answer to that. Malaj, please have a look in volume 11 itself. This is the same witness at question number at page 1428.
Yes, 1420.
At 1428, page question number 278.
Yes.
And I say, Malaj, have you produced the balance sheets today? I asked him a question earlier. The Honorable Tribunal said, no, you must put it on board. We sought a direction. They produced it, Malaj. Have you produced the balance sheets as promised before the tribunal for the year 2008 and 9? He says, yes, witness produces the balance sheet for the year 8 and 9. In this case, the one produced before the Registrar of Companies on the income tax, kindly take part B of so-and-so. Do you see in the, I'll just show the document, Malaj. The balance sheet is at supplementary affidavit, volume 3, Malaj. At page 377. Malaj will be able to see that.
না এগুলো থাকে 373 Mr. Chinnan.
377. It starts at 377.
Right.
At 378.
Yes.
Relevant portion.
Yes.
So Malaj, we ask him a question. If my lords may see the question first at 279. Do you agree? Do you see the sixth column from the bottom under the heading power and fuel? The comparative figures are given for the period of 147 to 2008. Do you see that? He says yes. Malaj, may please have a look at 378 now in the supplementary affidavit. And may see the rightmost column. On top, I'm saying figures for the head amount in rupees from 2007 to 2008.
Yes.
On top, rightmost column. And from the bottom, Malaj may see the column of power and fuel. From the bottom, it's the sixth column upwards.
Power and fuel, yes. Got it.
Yes. And Malaj, the expenditure in 7 and 8 is nil. So they are claiming expenses for this amount, Manoj, for this year. Now, Manoj, in the light of this cross-examination, the finding of the learned tribunal that there is no contra-questioning at all. I could have understood that there is a counter-questioning, we are not convinced and following is the reason. I could have understood that that would have landed them in the sphere of a plausible or a possible interpretation, Manoj. But this is a case where, according to me, number one, no evidence, Manoj, number one. Number two, the finding is completely contrary to record. The finding is that we did not question them on these aspects at all, which is incorrect, Manoj. So ultimately, an award which is based on a finding which is contrary to record, where they have not taken this into consideration and not even thought of mentioning it and glossed over it, so to say, Manoj, is something which, according to me, is patent illegality. Because I could have understood you taking this into your stride and saying, we have seen this, and give justifications that we don't agree with this, or on a holistic reading, X, Y, Z, but that is not the finding.
That may go within the domain of perversity.
That's the point.
There is there's no evidence.
Absolutely, Manoj. So that's the point that I'm trying to make. So,
Yes.
Manoj, three rather legal submissions there. One, no evidence. Second, the finding is contrary to record. Three, no appreciation at all of what I have cross-questioned. Both, according to me, all three, according to me, will land up in that sphere. As a result of which, Manoj, this amount of 7.95 crores could not have been awarded, given everything against me. Let's take everything to be against me. This could not have been awarded on the basis of the material that was before the Honorable Tribunal, the way as it is, Malaj.
All right.
Now, Malaj, may please see, and there is another argument, Malaj, and an interesting one there. To secure the performance of the contract, Malaj, I had given what is known as a performance bank guarantee. That performance bank guarantee, Manoj may mark it, is at the clauses for the performance bank guarantee is at page 557 in volume 5, very clearly stating that you have to give a performance bank guarantee for the operation, during the operation of the contract. Now, Manoj, that another aspect is that performance bank guarantee was never encashed by the opposite side.
So there is the contemporaneous raising of the issue and this encashment of the bank guarantee.
Yes, Manoj, and there is no encashment of the bank guarantee. Therefore, the argument is if my product was defective, so to say, you were under all your right to encash a bank guarantee. But your conduct of not encashing a bank guarantee is an estoppel by conduct. You could not have tomorrow, after not encashing the bank guarantee, raised a claim against me, stating that, look, because this is the issue. Now, Malaj will actually find this at page 114 in the minority award in volume 1.
All right.
Minority award relies on it heavily.
All right.
And says specifically. And says specifically that, look, and Malaj, may please have a look at that in volume 1 for a minute. Page 114, it's a short enunciation by the minority award. I'll take Malaj more clearly to the minority award in my coming submissions.
Okay.
Volume 1 of the main file, AP file.
Right. That is GA file. It is GA. It is GA1. AP1 এটা হবে যেটা আপাতত সহা Yes, Roman 5.
Yes, ma'am. At page
114 of AP.
Yes. Yes. Maharaj, may please see, yes, 114, point number 5.
Hmm, hmm. Not invoked. Very
Yes,
good.
not
Yes.
invoked. The performance guarantee furnished by so-and-so was also not invoked by the claimant, which further fortifies my finding that the defects and the problems in the machine and necessity of replacement of some part did not in any way arise out of any inherent manufacturing defect in the machine per se. I am unable to persuade myself to accept the claimant's case, and so on and so forth. So another aspect of estoppel by conduct and the argument that therefore this entire rejection on the basis that the machine was defective
Hmm.
is incorrect and in law could not have been taken because they were estopped by conduct.
Hmm.
Also, my lords, which I referred to the same point, my lords will find in point number 4 on the same page. I referred to very, very briefly when I was recapping, my lords, that also the repairs charges were paid at point number 5 at 114. These acts and conducts of the claimant show that the problem or defects complained of attended and rectified, and the respondent replaced parts arose not out of manufacturing defect in the machine, and therefore the claimant paid the bills without any protest.
Yes.
Being a corporate house, it can be safely presumed that the claimant was fully aware of its rights and entitlements under the contract. The performance guarantee furnished was also not encashed. I will refer to the award in a little more detail, Malaj, because according to me, a lot turns on the on this particular point. So, Malaj, with this, I have tried to, Malaj, put into perspective what has not been taken into consideration by the tribunal and where is the contrary evidence, and the findings in the award is incorrect, Malaj. Now I will shift to a little more sort of tedious task of showing to the court that what is the kind of evidence that was put on our behalf and how it has been completely glossed over.
Mr. Chandra, I'll request you to be as brief as possible because it's a section 34. You understand the constraints.
Absolutely, Balaz, absolutely. I will not.
You are precise already, so
No,
I hate to say this, but please, in spite of that,
No, I will. So,
yes.
In fact, there are some documents, Malad, we have put which may not be the part of the arbitral record. We are not referring to them. There is no point in a 34.
Yes, exactly.
I'm conscious of that. I'm not referring to them.
Right.
But just to obviate a challenge from the opposite side, saying that. So, but whatever I've referred to till now is all a part of record. Malad.
Part of
nothing is beyond the part of record.
Yes.
Now, Malad, may please have just to give a bird's eye view to what our defense was and how it was dealt was, and then I'll get into how the majority of what deals with it and how the minority of what deals with it. And I'll just show 1 or 2 or 3 pages so that the court is clear as to what is the kind of evidence we have put and how have they dealt with it per se. Have they taken it into consideration, not taken it into consideration, and so on and so forth. So, Manoj, we challenged the rejection primarily on 2-3 bases at the time.
You had no counterclaim, right?
I had a counterclaim, Malaj. I had a counterclaim of 38 lakh rupees in saying, and in fact, that counterclaim has been given by the minority arbitrator to the effect that the entire money which was to be paid to me as a part of consideration of the price was not paid to me. 38 lakh rupees were held back. And that was never paid to me, nor the turbine was returned to me. So the honorable minority arbitrator says specifically that, look, you can't have it both ways. You can't keep the turbine. You can't pay the money and claim the damages also.
Yes.
So he awards that in my favor. So we, Malaj, challenged it primarily on 4-5 counts. One of the counts was that, look, the damage to the machine was done primarily because of inept handling by the opposite side of the machine, and which is evident from what is known as a logbook of the CPP. So, Malaj, when they operate a machine like that, usually on the floor, they maintain a logbook where they maintain notings pertaining to what is the vibration level, who all are there, what is the shift, how many shifts are like, and who all are handling, what is their technical qualification, and so on and so on. So our challenge was was based on 3-4 levels. First was that it was run on really high vibration levels despite the vibration levels crossing not only the minimum criteria of 80 microns, but it went up to well beyond 200 microns to 300 microns to 400 microns, and the CPP was never stopped at that time. The logbook will show it continued to operate. They maybe they started and stopped it, and then they again started it without coming back to us and saying that this is the problem that we are facing of increased vibration levels. That was one aspect. The second aspect was, Malaj, we said that it was not handled by people who are adept in handling it in terms of technically. It's a very sophisticated machine. It has to be handled by people having minimum particular qualifications. And that is the evidence that we tried to put: unskilled labor and inept handling. That was not taken into consideration, Malaj. The other aspect, Manoj, we tried to show to the tribunal was on the aspect that there were frequent start and stop of the machine, which resulted eventually into the machine getting damaged. So, Manoj, in fact, I will first start with the majority award, just the relevant portions in the majority award and the relevant portion in the minority award, and something additional that I want to point out. Now, Malaj, please have a look at the majority award in the stay application file at page 117.
জি, এটা করতে ভলিউম এটা Yes, 117.
I'm sorry.
There the vibration.
Yes, Manoj. In 117, this is how they deal with the vibration. Please see. They say, I have carefully, it's just 2 pages, Manoj, 117 and 118, and they dismiss that point. I have carefully considered all the records, documents disclosed in this proceeding, and the evidence given by the respective witnesses. It was found that there was high vibration level while the said machine was put in operation. So they admit, Manoj, that there is vibration level. However, their reasoning is based on that, look, vibration level were high and it was not corrected, and that resulted into damage. But they don't go into the relevant aspect of that they kept on running. Now, please see. It was found that there was high vibration level while the said machine was put in operation. Several complaints were made by the letters, and it was recorded in the joint meeting of the parties about the said high vibration level. But there is no document disclosed in this proceeding at the instance of the respondent to establish that the claimant was responsible for such high vibration. On the contrary, the claimant has produced documents and has been exhibited in the proceedings to show that the said machine was being run at high vibration level, was observed even before the respondent's engineer who were present. It is also fact that notwithstanding several complaints have been made with regard to the high vibration level on the number of occasions, the respondent could not detect the cause of the high vibration level. In this connection, few letters are so and so. None of these letters were replied to by the respondent, nor had they denied the contents thereof. In spite of all such complaints having been made by the writings, and in spite of several meetings, the respondent could not find what was the cause for such big vibration. Since such cause could not be found by the respondent, it can be considered that the said machine was defective and was not being capable of being run according to the contract. There were further allegations of the respondent with regard to bypassing the trip level. This is important, Malad, and running of low loads. We showed evidence. They said sorry. It was specifically shown by the claimant by its evidence through its witnesses. Question number so and so, that the trip level cannot be changed by the operational people. It can be altered by original equipment manufacturer, that is the respondent. Further, this trip level ought to have been mentioned in an operating manual, which however was not done. This evidence of the claimant witness was not controverted by the respondent's witness. This is again, Malaj, contrary to the record. I do not find that the respondent has been able to establish and or provide its charges allegations as made with regard to bypassing the trip level. I therefore do not accept such allegation of the respondent. Now,
They
Manoj,
said they wrote letters to you and you did not respond and all this.
yes, Manoj. So they said they wrote letters, you did not respond, neither corrected it. Of course, from the logbook, it will be clear, Manoj. We came, we corrected it. We told them not to run at beyond micron levels, but they were not careful. Please now please have a look at the minority award, and I'll show you the documents. The reason why I'm showing the minority award is for the reason, Manoj, that the minority hasn't had the benefit of reading this at all. Minority made its own award on the basis of the record.
Where was that, please? You just referred
Yes,
to
Manoj. Yes, yes.
supplementary.
No, the minority award would be in volume 1, Manoj. In volume 1 of the AP file itself. First volume.
Yes. Yes, right. Got it.
And Manoj, may please refer to the portion just yes. Yes. Manoj, may please refer to 118. 119, I'm sorry. Page 119 at
Yes,
para
right.
35.
Right.
The minority says the issue of high vibration 35.1, I'm reading. The issue of high vibration levels in the machine has been raised by both the parties, while the claimant contended that this is a manufacturing defect, cause of which could not be detected and rectified. The respondent contended that the machine was run for prolonged periods at a load much below the prescribed minimum load by the claimant, which caused high levels of vibration, resulting in damage to the machine. On this issue, the parties tendered evidence through witnesses, which are considered hereunder. However, at the outset, be it noted here that the evidences tendered by the witnesses of the respondent are by and large based on logbooks produced by the claimant. So that's an admitted document, Malak, the logbook. It is their document which was produced after a direction from the tribal. They did not produce it initially. Then application was made for disclosure. In the disclosure, this came. Now let me see over the page, schedule 1, page 69 of the SOC of the contract under the heading so-and-so provides various parts of the equipment related to vibration specifically detailed in items number so-and-so. The claimant has no grievance as to fittings and supply of those parts and equipments by the respondent. Those are relatable to control system of the vibration in the TG set, particularly turbine. In para 38 of the affidavit of evidence of claimant witness 1 stated that because of defect, vibration levels reached 92 microns, which was reported to the respondent. In answer to question number 317 to 326, CW1 admitted that if wet steam goes inside the turbine beyond its limit, the turbine will create vibration and it will trip. He also admitted that the claimant should not have operated the machine at such high levels of vibration recorded at Exhibit 69 at page 243 of the SOC itself, and that the respondent asked to stop the machine. In question 327 and 328 of the complainant witness 1, of the claimant witness 1, admitted there were huge vibration levels as the machine was run with load below the prescribed minimum load. In question 341 to 346, CW1 admitted that all rotor machines vibrate, but there is a limit to vibration when the generator is in operation. If the vibration limit exceeds and still the machine is allowed to run, then damage may occur in generating set, and there is agreed vibration limit in the specification of the contract. He said that it is very important to maintain vibration limit, and if vibration levels go up, machine would trip. In so-and-so, CW1 said that the cause of vibration could be manufacturing defect, operational defect, improper erection, and if the steam carries water, the vibration goes up to so-and-so. In examination, now this is my evidence, Malat. In examination in chief of the RW2 in question 50 and 55 said that the logbook notings would show that the vibration levels at times were 300 to 400 microns, of which fact claimant had knowledge. Vibration would not be there if machine is properly handled. There is a continuous vibration monitoring system for automatic tripping, and that running the machine at high levels of vibration would lead to bearing damage and damage to machine. In answer to question number 273, in cross-examination of RW2, said clause of vibration could be many, and that set was kept running at those levels, which proved fatal. He said in October 2007, high vibration level occurred in between 70 to 80 microns. Bearings were damaged, apparently due to high levels of vibration. Bearing were damaged apparently due to high level of vibration, and it came to his knowledge from the logbook when vibration level was in excess of 200 microns. The machine should have been stopped, but was kept running at that high level of vibration even for 10 to 15 days. In answer to question number 379, RW2 stated that safety system was bypassed to avoid undesired tripping to keep the machine running, and this was done by the operating people, and that logbook recorded that vibration level was much lower, and the factum of bypassing of the safety tripping limit is evident from the logbook. He says that if there is any design defect problem will always be there, and not that it would occur 1 or 2 days. Electrical engineer noted in the logbook that safety tripping systems was bypassed, and bypassing started to avoid false tripping when even the actual vibrations had not reached the trip levels. RW3 in the affidavit of evidence stated the logbook he found that boiler and tripped, but it was restarted immediately, and rear bearing vibration levels were 49, 52, 63, 70, 101, 121, and 163 microns, and those were much above the ISO standards on 27th of January 2007. On 30th of January 2007, and vibration levels were 357 and 245 to 400 microns respectively, and that the claimant should not have operated the machine at such high level of vibrations, which could have damaged the machine permanently. In cross-examination, he stated that all his observations and opinions are based on logbooks, and that the vibration is one of the cause contributing to the damage of the machine. RW4 in his affidavit of evidence stated that the logbook he found from the logbook he found that vibration levels were excessive and the set should have been stopped. In cross-examination, he said that his statements in affidavit of evidence inter alia relating to handling, operation, and vibration levels in the machine are based on logbooks. In view of the discussions above, and considering the evidences based on the logbook, I find and hold that the claimant ran the machine at very high levels of vibration, bypassed the safety system tripping limit, and breached the contract terms, which are factors causing damage to the machine. So, Malas, this is the kind of appreciation that the minority arbitrator does in terms of stating what they have said fairly. He says that they have said that you were not able to stop the machine, the vibrations and so on and so forth. But what is important is, Malas, 3 witnesses from my side, logbook produced, and I'll show the logbook also for the clarity of the court. In the logbook, clear notings of the machine running from a level higher than what, not only a level higher, but 3 to 4 times higher than what it ought to have run. In that kind of evidence on record, Malaj, could the majority tribunal sort of swept under the carpet all of this evidence and just merely refer to the evidence of the claimant without doing a holistic job of referring to both the evidences and then reaching at a conclusion? If my lords will see the majority award, there is no reference. I'm sorry, there is absolutely no reference to the evidence that is led by the respondent. Rather, what in the majority award, what is stated is simply that they have not been able to refute the evidence which is stated by the claimant. But that is not the case, my lords. And in fact, I'll show, just to be very clear, just so that my lords, and more importantly, my lords, the minority arbitrator, just to be very clear, and I mentioned it earlier also, the minority arbitrator is not my nominee arbitrator. We failed to appoint a nominee arbitrator. He was appointed by the Honorable Court. That's a separate issue, my lords, that arbitrators are to be impartial, irrespective of whoever appoints them, whether it's the court or whether it's the party. But for whatever I can, for whatever it's worth, I'm stating this across the board that somebody appointed by the Honorable Court is on a much, different footing rather, as compared to somebody who's appointed as a nominee arbitrator. Malads are aware of it. I would not say anything more than that. But having said that, Malads, now please have a look at the kind of evidence that has come on record, and the minority arbitrator. Although, Malads, frankly, I don't need to go into what minority arbitrator says. He has done a fairly extensive job in terms of what has been put on record. He has said that this has been put on record, but I just want to show one aspect on the logbook and I'll stop at that. I won't refer into great detail into everything that has been said. It will be deep, it will be duplication, Malaj. And I don't want to do that. Just have a look at the logbooks and just few pages of the logbook, which will be very, very clear. Malaj may have volume 1 of the supplementary affidavit. That is where the logbook is produced. Yes. And Malaj, sorry.
Yes.
Just. Yes, Manoj. Manoj, may please have a look at page 58 onwards. It starts, the logbook starts at page 20. Logbook starts at page 22, Manoj. And the relevant entries, just for showing the Honorable Court. Although, of course, Manoj will not reappreciate, but just to show that this was there. Is starting from page 58, Manoj.
Yes.
These are logbooks, Malaj, which are prepared on the floor. This is not something that is prepared by me. It's their document, Malaj, and
Since it's an admitted document, then Mr. Chandra, we need not look at it.
It's an admitted document, and the factor
You rely in your
in my case. Yes, Malaj, yes. And in fact, the aspect of the microns running into 200 and 400 is very well there, Malaj. It's not as if it is absent.
That is an admitted both sides.
Malaj. Now, Malaj, may please look at the...
Mr. Chandra, had they produced the letters, proved the letters which they wrote to you, they said that you did not respond.
Yes, Malaj, those letters are on record.
Those are on record.
Those are on record, of course.
But you said, where do we find that you had actually responded to those or were present?
So Malaj, I'll tell you. So their entire case, Malaj, is based on writing letters to us.
You not responding.
And we not responding. For the reason, Malaj, that the moment they wrote a letter, our engineers were there at the site, correcting whatever was required to be corrected. And
where do you find that? I mean, your end.
No, Malaj, it's an admitted position. My affidavit says so. My affidavit says that my engineers were there, that they also say your engineers were here. They say that they were not able to correct the machine, is what they say. Right. Despite repeated visits, despite doing X, Y, and Z, your engineers were not able to correct it, and so on and so forth. That's what they say. We, of course, say that every time we visited, we charged, you agreed, things were corrected, we went back. Because of your inept handling, because of your running the machines at a very, very high micron levels. That is
those repairs were done by your engineer only.
Yes, Malaj. Repairs were done by us.
The one which they now want to recover, the cost of...
Yes, Malaj. Yes.
All right.
Yes. That
so
38 lakhs.
Right, 38 lakhs something. So they called your engineers, they had it repaired, they paid you without demand.
Yes.
Despite having a performance guarantee.
That's right, Malaj. Despite having a performance guarantee, despite the guarantee clause saying that I will cover all the costs during.
Yes. During the guarantee.
During the guarantee. That everything will be covered as far as the guarantee is concerned. They could have easily asked me that, look, sorry, no need. You correct it or we encash the bank guarantee. Simply.
So there you say stubble operates.
Yes, Malaj. There I say that once you paid, I raised the bill, once you paid without demur, once you did not say that I am reserving my right to recover it from you in the eventuality you are not able to correct it or put me to notice.
Nothing.
Nothing of that sort, which has come on record.
Very.
Now, yes. Now, Malaj, may please see. So therefore, my first point where I say that it has not been, my evidence has not even been looked into, is the aspect of the machine running at very, very high vibration levels. Now, please have a look at the second aspect. Should I show Malaj those cross-examinations of my witness on that point? Although that's covered by the minority award, frankly.
Yes, it has been discussed.
Yes, it has been discussed. Yes, it has been discussed very, very clearly. Yes. Now, Malaj, now I say that Yes, one important aspect, Malaj, I say, and which has come on record, which the minority tribunal relies on. I say that they actually bypassed the security tripping system
To
just
continue
not-
running the machine.
yeah, just to keep running the machine.
All right.
And that is something, Malaj, which is recorded in the logbook.
Hmm.
The logbook says so specifically. My cross-examination says so, Manoj, and the logbook at page 54 or at page 44, supplementary affidavit, if Manoj may want to see, one of their persons clearly says that please do this. Let's stop getting bothered by these, raised micron levels.
Page 44.
Page 44, the supplementary affidavit, Manoj.
Yes,
It's
supplementary.
a handwritten document,
Yes.
and I will just show Manoj, page
Seven.
44.
Yes. It's there.
Yes, Manoj. He says, please, at 9:27, information was given to Mr. So-and-so to check the turbine vibration probe. And if found that the set functioning on the probe, then get the probe rectified by bypassing to avoid one unwanted tripping. Observation is as below. And then he gives the observation also that after I bypassed it, after I bypassed it,
Hmm.
the micron level decrease. So in a logbook, one of the technicians says, look, let's be bothered about, how to generate electricity. Let's not get into this micron levels.
Yes.
Let's bypass it and then we'll see whatever happens, will happen. Ultimately, I'll have the CMD to answer to that we produced electricity. So this is the kind of evidence that has not been looked into. It's not about the question of appreciation of this. Had this been looked into and mentioned and talked about, and stated, or at least would have stated that this is not worthy or whatever. This is untrustworthy. But nothing of this sort was done, Malaj. So, Malaj, I'm sorry to say, so the majority award seemed like a predetermined award.
Hmm.
It's one thing for any arbitrator to discuss both the aspects, to state, okay, this is what has happened. I've appreciated both the sides. I don't agree with side X because of the following reasons. No, the reasons may be right or wrong. That's a separate issue. But what I'm stating is that there is no reason. As far as I'm concerned, there is absolutely no reason.
Hmm.
So, Malaj, that's on the aspect of the vibration levels. Now, Malaj may come to on the second aspect, where I state, Malaj, that unskilled manpower was taken or was kept there for handling this product. And that is something which contributed to the damage of the machine per se. And then the other point is, Malaj, frequent start and stop of the machine. Now, Malaj, may please have a look at
Mr. Chandra, I'll take that break and come back in 10 minutes.
okay, Malaj.
Yes, Vishnu.
Malas.
Unskilled labor now.
Unskilled labor now, malas.
Yes.
Malas may refer to yes, Malas. Malas may please first refer to the minority award since we were looking at the minority award. Malas may refer to page number 116. 116 of the volume 1
Yes.
minority award.
That was in the supplementary affidavit.
Normal, no, AP, normal AP volume 1.
AP.
Yes, yes.
Yes, please.
Yes, ma'am. May refer to para 32. 32, one I'm reading at the bottom, Malad. Regarding handling of the machine by inexperienced employees, the claimant relied upon a list of employees engaged in CPP, marked at exhibit number so-and-so, of the affidavit of evidence of claimant witness 1 and submitted that those employees are very much capable of running the plant. CW1 further deposed that qualification and experience of the employees operating the machine and said that any person, even with 1 year experience, having expertise in computer operation, can run the machine effectively. Both RW1 and RW2 in their affidavit of evidence stated that satisfactory performance of the TG set supplied was dependent upon the machine being operated by experienced person as prescribed in operating manual. This statement has not been challenged by the claimant and no question was put in the cross-examination. Further, in answer to question 58 and 59 in the examination of RW1 deposed that inexperienced people were operating the machine and startups, and as per records, this part of the evidence could not be disproved by any contrary evidence. RW2 in his evidence referred to clause 19.1 of the contract to say that the suitable and efficient staff and operators were required. Referring to CDM marked as Exhibit Annexure 3 and 4 in the affidavit of evidence, he pointed out that technical problem may be faced in running the TG set due to lack of the proper experience. In answer to question number 148, 156 in cross-examination, he categorically deposed that machine was run by inexperienced persons and this fact was recorded by the claimant's engineers in the logbook. So, Maharaj, finding in the logbook by claimant's own engineer. RW4 in his affidavit of evidence also reiterated the same. In question 185, he deposed that the operator did not have basic knowledge of the operation. Respondent's letter dated so-and-so has preferred to show that claimant has advised to provide suitable and trained manpower for operation of TG set. He deposed that after change of management in power plant, machine operated continuously beyond October 2007 to 2009. Question number 498 and 502, that is after CW1 left the service. The claimant could not produce any evidence to counter these witnesses. None of the employee engaged in the running of the machines has been examined by the claimant. Considering the oral and documentary evidence on record, I am of the opinion that the respondent has proved that the machine was run and operated by inexperienced and unskilled persons which caused damage to the machine. Now, Maharaj, may please just expose this to how the majority deals with it. Maharaj, may please refer to majority is in the stay application file, Maharaj. And may please refer to yeah. Yes. Maharaj, may look at 1-1. At 114.
Yes. Non-trained.
Yes, Maharaj. They say, before I deal with this aspect, I must record that admittedly the TG set was not only a very sophisticated equipment, but was also fully automatic. At 114 minutes of the application,
Yes.
of the stay application.
Yes.
Before I deal with this aspect, I must record that admittedly the TG set was not only a very sophisticated equipment, but was fully automatic. It was submitted in course of the argument that normal human intervention was generally not required to run the system. In any event, the contract did not specify that any particular or special training was required to be taken by the personnel of the claimant to run the same. In any event, the contract contains a clause, being clause 19, to train personnel of the claimant. The respondent has not disclosed any document nor had submitted in the course of its argument that any such training as contemplated in clause 19 of the contract was given to any personnel of the claimant. It is also not the case of the respondent that in spite of agreeing to give such training, the claimant's personnel had refused to take it, or they were incompetent to take such training. Further, the allegation of inaptness, which have been made in the present case by the respondent, also appears to be not supported by any documentary evidence. This is what they say. So they don't refer to the logbook. They don't refer to any other document on record or my affidavit of evidence, which is based on the logbook. It is matter of record that the respondent's engineer representatives were almost all through present at the site, either for running of the TG set or for dismantling of the unit, owing to the defect found therein. In no occasion any complaint of whatsoever nature was made by the said engineer's representative of the respondent with regard to any inaptness of the claimant's personnel. Further, it is important to note that the set, which is wrong, Manoj, he refers to the minority award, refers to a letter we had specifically written to them, stating that because your set is being handled by inept people, therefore these problems are coming, and the minority award refers to that letter. I don't want to go into it, but I'm just pointing it out. This aspect is wrong by stating that we never pointed it out, that it is being run by people who are inept in handling it. Further, it is important to note that the said boiler had from time to time suffered due to various problems. I do not find any particular given by the respondent either in its counter statement or in any of its affidavit of evidence filed by its witness of any such reference of inaptness. The allegation as made appears to be absolutely vague and mechanical. This is also incorrect, Malad. The tribunal is saying that I do not find any material on record by any of the affidavit of evidence of the respondent. I say so specifically, Manoj. I have led two witnesses who have examined. One of my technical witnesses only a graduate of IIT Kharagpur, where he looks at the logbook and gives his interpretation of the logbook and nothing else, Manoj, as an independent person. And he also specifically states in his affidavit of evidence, where he has not been cross-examined on that particular point, which the minority award refers to.
But there is the other aspect that clause 19 impels you to impart training. You have shown nothing to show that you have trained them.
No, Malad. So in fact, the CDM report says the CDM report was a report, Malaj, which was prepared prior to the.
What is CDM, Mr. Chinda?
Yeah, CDM, Malaj, is a report which was.
Yeah, please.
Oh, I'm so sorry, Malaj. I'm so sorry. I'm
Yes.
so sorry. Yes, I'm so sorry.
CDM, what is CDM?
Yeah, CDM, Malaj, is a report which was prepared by the by an expert in the field called Avant Grade, Malaj.
What is the meaning of
Yes,
the full
CDM
form?
is, yes, Manoj, it's like a feasibility report for that particular machine to be set up in that area, both in terms of technical, geographical, and mechanical sense. They give a feasibility that you would require to do this. This is what you would want, and these are the challenges that you would be facing. That CDM report is on record now.
Understood.
Yes.
I will show it.
Full form is claim development mechanism.
Thank you. Yes, Michelle. Please continue from where we stopped.
Yes.
Thank you.
Yes. So, yes. So, Malaj, so the point that CDM reports refers to the fact that this is a kind of apparatus which requires sophisticated handling, and that there is dearth of that kind of sophisticated labor in that area. Therefore, you have to have sophisticated labor, and you'll have to pay them a little higher. So this was there, Malaj, even before. If Malaj want to have a look at that, then Malaj may please have a look at the CDM report itself, which is at page 1478 at volume 11. For a minute. I will just refer to that one paragraph where it says so specifically. Volume 11 of the AP file. Yes.
Yes, it is with me.
Yes, volume 11, page number 1478, Malas. This is where the report starts. Relevant is at 1494. At 1494, I am reading Malas, number D. Other barriers.
Yes.
Other barriers without project activity for another specific reason identified by the project participant, such as institutional barrier or limited formation, managerial resources, organizational capacity, financial resources, or capacity to absorb new technology, emissions would have been higher. Skilled and properly trained labor to operate and maintain this type of BF gas CPP is not easily available, leading to high risk of equipment despair and malfunctioning and other underperformance. Due to the lack of skilled manpower and to overcome barriers related to organizational capacity in ensuring smooth running of the unit, NML is Neometallics Limited, which is the respondent here, had to recruit 10 numbers of specially trained people who are well versed in the power plant operation with specific knowledge of waste gas based power plant. In order to retain the newly inducted technical manpower, NML has to provide a compensation package which is significantly higher than those in the existing setup. The organization had to invest in overcoming barriers with respect to this.
Mr. Shinde, this past tense usage of past tense is grammatical error. I mean, it had to means it had employed or it is to employ.
No, Manoj,
has to, once it says it has to.
Yes, no, Manoj, if my lords may see, the date of the report is 22nd of December 2006. So this was prior to commission. Yes.
Otherwise, it cannot be a feasibility report of sorts. Right?
Absolutely, Manoj, absolutely. So this was prior to commissioning, so to say, because commissioning happened only on December.
Because they say NML had to recruit 10. So
yes.
you can understand that who are well versed.
Yes.
Yes, has to, then has to provide a compensation.
Right. And in fact, my lord, I will take my lords to the relevant graph or the relevant chart that has been maintained by the opposite side as to the qualification of people who have handled the machine.
But how do you know that is the right qualification? How does the tribunal know?
No, so my lords, the tribunal, so in the contract, it is provided that skilled labor is required.
Highly skilled labor? Yes, highly skilled labor.
Yes. So anybody who has to have either an engineering degree or beyond an engineering degree, or even a shop operator who is an experienced person by normal standards, and Manoj will see what is the kind of people which had been employed.
Very good, very good. So they had to show that those specially trained people were retained.
Yes, Manoj. Retained, employed, and were associated with the operation.
And they only say that 1 year
is enough.
Yes, is enough.
Is enough, is what they say, Manoj.
Right. Very good.
They say even 1 year of operation because it is an automated
system. Yes.
So therefore, we don't need any great.
True.
Any great nuanced talent there.
Mm-hmm.
Then Manoj, may please see we were at 115, Manoj. And we were at 115.
115, yes.
Yeah. Further, it is important to note the boiler had time to time suffered due to various problems. Yes. Then para 2. Further, with regard to the allegation of inaptness of the claimant's employee in connection with the operation of the said set, it is found that the record disclosed that the said machine had in fact run as per the advisor and instruction of the respondent engineer, in spite of finding the said high level of vibration. These are all matters of record, which have been specifically relied on by the claimant in the course of its submission. In connection with these allegations, the respondent, the claimant, has proved a document, Exhibit 110, showing the number of persons who were engaged in operation. Considering the said exhibit and the other documents and submissions made in this regard, I find that amongst the persons who were involved in the running of the said set, most of the persons were qualified engineers, except few who were ITI past mechanics. It was also the case of the claimant, which was also not disputed by the respondent by any mode, that in each shift there was one engineer who was assisted by one operator. The control room was also manned by qualified person, and such operating people were in other sections like boiler, water treatment plant at the time of startup, etc. Question number 367. Other experienced technical hands were inside the control room to give instructions for closing and opening of the valves, undertaking physical check, for maintaining the parameters according to the claimant in order to operate the turbine. Required and experienced people were engaged by the claimant throughout. So Malaj refers to the witnesses of the claimant. No reference to evidence that has been tendered, no reference to the CDM, no reference to my cross-examination, no reference to the positive evidence that I have brought on record. Just to give a glimpse of what is that kind of evidence, Malaj, may please have a look at the qualification of the people at page 684 of the supplementary affidavit, Malaj, which would be in volume 4 of the supplementary affidavit. No, Malaj, it will be volume 5 of the supplementary. Sorry. Just yes,
volume
yeah.
5.
684. This is the list which is annexed by them, Malaj.
Yes, yes.
And these are 53 people, Malaj. Not even 5 have the experience of more than 5 years. 15 are freshers. And 692 would actually show, Malaj, who was handling the TG set. So these were actually the number of people who were employed for the work. None of them, not even 4 over 5 of them, have relevant experience of being an engineer of more than 5 years. And at 692, these can be, Malaj, compared to the people who are there at page 684. Mostly freshers, Malaj, operators. And these are different shifts, B, C, A, B, on 12th January until, I'm just giving an example. When these are collated to 684, when 692 is compared to 684, Malaj, it's not that as if engineer was present at all times, is what the finding of the learned majority of what is. Sometimes only the floor operators are there and nobody else is there. Sometimes only freshers are there and nobody else is there. And on top of that, Malaj, I will show a document of their own logbook where their own supervisor is stating that there are no shift in charges which are there. Please have a look at page 34 of the supplementary affidavit 1, which has logbook. Supplementary affidavit 1, Malaj?
Yes.
Page 34.
34, yes.
Yes. Malaj, may please have a look. Yes. He himself says, this is one of the persons there in their own organization. At present, only one shift is available with the plan.
34.
34 of the supplementary affidavit, Malaj. Volume 1. It's a handwritten document, Malaj.
Yes, yes, yes. Got it. Yes.
At present, only one shift is available with the plant. What about the other time shifts without shift in charges? Except one shift in charge, is it okay to run the shift on the faith of newly joined persons?
What is this? This is a minutes.
This is a entry in the logbook, Malaj. This is a part of the logbook. The logbook starts from.
All right. Yes.
Yeah, the logbook starts from page 22. And this is their logbook, Malaj, not mine. So he says that there is no site in charges. Then he says, is it okay to only run it on one shift? And that
He asks a question in the logbook. I mean, that's peculiar.
I'm sorry, Malaj?
He asks a question in the logbook.
No, what he says is it's a sort of a
Is it okay?
satire in the sense that if he's trying to tell to the administration that it is not okay and you should have somebody else and not only freshers.
In charge, is it okay to run the shift on the faith of religion?
I'm sorry.
So this is his dissent, sort of. I mean,
Absolutely. It's like a
they produced it.
they produced it, Maharaj. It's their document. It's not my document. It is not since it's a logbook of the machine, it can only be with them and not with you.
Exactly.
And not with me because they were operating and this was produced in the direction of the Honorable Tribunal.
Oh, right. Yes.
Yeah,
They did not initially.
Initially, they did not, and this was produced after an application or oral mentioning was made. This was told. On 24, point number 3, on 24-hour basis, one mechanical maintenance team and I can't decipher, Malaj. One mechanical and maintenance team should be present in the CPP.
Client maintenance,
I
whatever.
don't want to say like
Whatever,
this.
something maintenance.
Yeah, should present in the CPP to get their system clear, mandatory to avoid tampering of system and production. Communication channel regarding boiler starting to taking load should be very much clear to the end and one with the name of responsibility. Again, these are the observations which is seen so that persons are with the CPP should come forward with their opinion and observations to get system healthy. Is what he says. So, and this is January of 2007, 20th of January of 2007 is the date Malaj who's written and gentleman's name is Sanjeev. So with this kind of evidence Malaj on record and with my 3 expert witnesses coming forward and stating that you had to have more specific and more trained individuals. The only way it has been dealt with in the majority award is to say that yes, 1 year was sufficient. They were there and it is sufficient to have to have this kind of handling, and we are not getting into that greater detail, and that's the end of it. Now Malaj may see the aspect of if Malaj actually want to see my evidence, I can indicate what my evidence is. Need not go to that. Okay, I'll leave it at that, Malaj. Now comes the point of frequent start and stop. Please have a look at page 117 of the minority award in the application file, volume 1.
One 117.
117, Malaj, of the
There is a vibration level.
yes. No, vibration level Malaj was at 119. 117 is frequent start and stop at the bottom. 33.1.
This is the application.
The application. Yes. This is the application. This is the application file, volume 1. AP file. AP. Application, I'm sorry, Malaj. Application is actually the stay.
Application is yes.
Stay, yes, I'm sorry.
Both are applications, definitely section 34.
Yes, no, Malaj, I'm sorry.
So,
I'm not very well versed with the nomenclature.
No. Application.
Yes.
Both are called applications. So
Malaj, may I have a look at 117?
117, yeah.
Yes. At the bottom, Malaj, 33.1.
Right.
Frequent start and stop. Now, I'll refer to the minority and then to the majority. It says frequent startup and shutdown. Regarding frequent startups and shutdown, respondent witness 2 in his affidavit of evidence stated that principal problems in operating TG set was frequent shutdown and startup. As a result, the plant and boiler operations had not stabilized, and also that the plant itself was shut down and restarted regularly, which is detrimental to the life and functioning of the turbine and caused damage. And in question 255, he reiterated the same. Further evidence in the same line are question 256, 59, 64, and 67. In answer to question number 270, respondent witness 2 categorically stated that every time breakdown took place during starting up after a prolonged running and stoppage. From the log sheets disclosed by the claimant on direction of the tribunal, it was seen that the frequency was substantially higher, and many times set was being restarted and stopped every alternate day. Frequent shutdown is one of the reasons for failure of the set. Significantly, frequent startups and shutdowns as deposed by the RW2 based on the logbooks could not be disputed by the claimant. Evidently, the logbooks disclosed by the claimant bear the testimony of mishandling of the TG set by inexperienced persons, and frequent startups and shutdown by the claimant prove the respondent's contention beyond doubt. RW3's answer to question number 16 and 17 are also on point of frequent startups without maintaining requisite gap between the two. Logbooks produced by the claimant on demand of the respondent and direction of the tribunal and marked as exhibit E, F, and G during the proceedings revealed so many facts, figures, and notings and comments entered therein which could not be disputed by the claimant, and based on the same, RW2 and RW4 deposed in support of the case of the respondent. RW4 also deposed and filed his affidavit of evidence based on the logbooks. Considering the oral and undisputed documentary evidence, I am inclined to hold that the respondent had proved their point of defense of frequent startup and shutdowns of the TG set by the claimant being detrimental to the life and functioning of the set. Now, please see, Manoj, how the majority award deals with it. At page 116 in the stay application file.
Yes.
Cursory, Malaj, don't refer to anything. No evidence referred to, no statements made. Please see at page 116. It is evident from record. I'm reading under the heading start up and stop.
Yes.
It is evident from the record that the said machine was not being able to perform continuously, and it had in fact operated intermittently. Such intermittent functioning of the machine was due to the said problem found in designing and manufacturing, which was tried, which was tried to make good by respondent from time to time. Therefore, the question arose as to whether the said machine was actually commissioned or not. I have already held here and above that by reason of these continuous defects, stoppage of machine, dismantling of the machine, repairing of its parts, and further installing of the same was not amounting to commissioning within the meaning of the said contract. With regard to the allegations in connection with the startup and closing up are concerned, it can be said that although admittedly the respondent's engineer were present at site, they had never indicated or identified any mal-operation of the machine by the claimant's personnel, nor they had reported the same to the respondent, and consequently the respondent never had intimated such to the claimant. In support of this allegation, even not a single piece of document has been produced by the respondent. I therefore do not accept these allegations of the claimant with regard to not following the startup procedure and others.
So the burden has been shifted to you.
Yes, Malaj, and my evidence, which is based on the logbooks produced by them, has not been taken into consideration at all. They simply state that, look, you contend your burden, no document, sorry. We say logbooks produced, we depose on the basis of logbooks. You don't cross-examine us on the startup and stopping on that point. Therefore, it had to be considered. And logbook Malaj was produced only later. It is not when I was making a claim, it was not available to me. Sorry, when I was making a defense, they were the claimants. When I was making the defense, the logbook was not available to me. It is only after the logbook was made available that I filed my evidence based on that logbook. So these are the three, and I would just draw my lord's attention to the minority award just to put in perspective what are admitted facts, which are not disputed. Manoj, please have a look at page 113 of the same minority award and volume 1 of the AP file. It just helps to put in perspective that these are admitted positions, irrespective whether it is contained in the minority or the majority award. I don't think that this will be controverted by the opposite side. But these are admitted facts. And please have a look at that. Manoj, that's para 27, 113 for a minute.
Yes.
It says, the claimant, I'm reading, before the evidence of the engineer witnesses are considered to decide the subject issue, the admitted facts on record are noticed as under. The claimant relied upon a chart showing number of running days of the turbine from 20th of January 2007 till 18th of June 2009. From the chart, it appears that the machine ran without any trouble continuously for long periods. Example, 80 days from so-and-so date, 32 days from so-and-so date, and 65 days from so-and-so date, 29 days from so-and-so date, and 47 days from so-and-so date. And there are other days of trouble-free continuous running of the machine mentioned therein. Question 515 CW1 confirmed that the chart is a compilation from the logbook. The claimant does admitted the continuous trouble-free running of the machine as shown in the set chart. Of course, Manoj, their case is that look, continuous running meant continuous running for 18 months. And not these. In fact, they rely on this to say that look, it has only run in bits and pieces.
Yes.
That is their point of reliance on this particular document. That look, the fact that it ran for 80 days, 90 days, 30 days, and didn't run for full 18 days or whatever, 2 months or 5 months continuously, is an indicator that it was not a good machine.
This is not commissioning, proper commissioning.
They say exactly, Manoj. That's
That is
that's what they say. We say, Manoj, it was of course commissioned,
Right.
ran for substantial period of time, therefore within the period of warranty, and therefore cannot be manufacturing defect. Point number 2, and these are admitted, Manoj, because this is a document placed by them, produced by them. It's just the interpretation that the tribunal is. Another admitted fact on record is that machine was delivered, erected, and commissioned on 28/12/2006, which I had shown Manoj earlier. It has come in their affidavit also, and was in possession of and used by the claimant till 27th of July 2009. Barring the days of repairs, when they intimated to the respondent as to the failure of the machine and purchasing of a new turbine. Vide page number so-and-so of the SOC. This rejection by the claimant was made after 2.5 years, when the guarantee period of 18 months from the date of commissioning long expired. Even if the point of non-commissioning is taken against me, Manoj, I shift to the second clause, to the second portion of clause 14, that 24 months from the date of supply.
Yes.
Even that had also expired. Much prior to 27th of July. That had to happen on 28th, if at all, had to happen on 28th of December of 2008. Rejection is only 27th of July 2009. Good 8 months, Manoj, good 7 months before that.
Yes.
By and under clause 7.1 of the contract, parties agreed that the property in the goods shall pass on to the purchaser immediately once the machinery and equipment is handed over to the purchaser at its Durgapur site. This clause is in consonance with section 17 of the Good Sales of Goods Act. So the property was theirs, Manoj, the moment I supplied. Of course, the amount of 38 lakhs was not given to me, but as per the operation, as per the contract, and as well as section 17, it's clear. Over the page, Manoj, there is yet another admitted facts. Admitted fact needs to be highlighted here on the above issue. The respondent was contractually bound to provide necessary services free of cost to the claimant whenever sought for during the warranty period. Admittedly, on several occasions, the respondent sent their men and engineers at the claimant's site to attend the problems and or defects complained of. In respect of all such visits, the respondent raised bills of cost of replaced parts upon the claimant and expenses incurred by deploying their men and engineers, and the claimant pays those bills without any protest. Which is also, as I say, estoppel.
Yes.
By conduct. Then point number 5, these acts and conduct of the claimant show the problems and or defects in the TG set complained of and attended and rectified by the respondent, as also replaced parts arose not out of any manufacturing defect in the machine, and therefore the claimant paid bills without any protest. This is, of course, Manoj's interpretation, so to say, but what he's saying is that because you paid, therefore I'm inferring this. Being a corporate house, it can safely be presumed that the claimant was fully aware of its right and entitlement under the contract, whether the performance guarantee furnished by Malaj have already read this, point number 5 and 6.
Yes.
Now, Malaj may please have a look at, Malaj have already referred to commissioning and decommissioning over the page, and just see the minority awards. Eventually, Malaj, the minority award at page 127.
Yes.
At 127, Manoj had asked me that whether that amount has been given in the counterclaim or not.
Yes.
That is covered at para 42. The respondent has a counterclaim for a sum of rupees 38 lakhs on account of balance price of the TG set sold and delivered to the claimant. The price of the TG set is agreed under the contract. Therefore, right to receive the unpaid balance price of the TG set by the respondent cannot be denied. The claimant did not dispute the agreed price of the TG set. The claimant denied the respondent's right to receive this claim for the reason that the TG sold and delivered was inherently defective and ultimately had to be abandoned by purchasing a new turbine. Since this case of the claimant has been rejected and the claimant has also failed to prove the entire agreed price of the TG set has been paid to the respondent, there is no reason that the respondent should be denied to receive this claim. Accordingly, the counterclaim succeeds and the claimant is held liable to pay the said sum of rupees 38 lakhs to the respondent. Be it noted here, lack of demand by the creditor of its dues does not absolve the debtor of its debt to the creditor. Then finally, the interest, Manoj, and then the cost is also given to me.
The majority award refused this counterclaim.
Yes, Manoj, they refuse. They say that since you have not been able to give a defect-free machine, therefore there is no point of this. So that's the anomaly, Manoj. Neither there is a direction by them to return the turbine to me, nor there is a direction for payment of this 30 or adjustment of this 38 lakh rupees also. I could have understood if it was that either you return the amount, either you return the scrap for whatever it is, the turbine as scrap for whatever the worth its value is, or you make the payment good and then adjust that amount from whatever is due to be given to the claimant according to the learned majority award. Now, Manoj, may please just this, I'm on the last leg on completing my factual basis, Manoj. Just one second. I am not, Manoj, I am not deliberately, although I have a lot to say, but I am not deliberately referring to the details of the evidence which has been captured here and otherwise of at least my. I'm not doing that. If required, Manoj, in rejoinder, if required.
Yes,
If
exactly.
required in rejoinder, if
They
something
do
is
it, and if it's necessary, then in
yes,
rejoinder.
Manoj. So I'll refer to that. Other than that, my lords may just, my lords have actually read up most of the portion of the award. My lords may now just refer to one portion which I want.
You have read the majority of the majority award as well as the majority of the
minority award as well, Manoj. Yes. I'm so obliged. I'm so obliged, Manoj. And
yes,
just one. Yes, Manoj. So Manoj have actually referred to the majority award. So with that, Manoj, as far as the factual basis is concerned, it's over. The legal basis, Manoj, I'll just seek a very short accommodation of either the next week or the next to next week. I'll put in my compilation of judgments. I'll supply to the Honorable Court earlier.
Right. And to them also, so that they can
Yes,
also.
yes, of course.
Yes.
Yes, I'll supply to both the sides so that we are ready, Manoj, on the next day on that point. And then perhaps on the next day, Manoj, the opposite side can begin if I conclude on the legal submission.
Mr. Shindra, I'll keep it on 28th because 21st I may have some other bench or something.
No difficulty, Manoj. If I can just confirm, Manoj will give me a moment.
Just check up, please. Because you will have to continue.
Yes. Good 28th. Okay.
Please check up.
Yes.
Yeah,
would it be possible for Malayads on 28 to fix it for a time at 11 o'clock? Is that something which is accepted, Manoj?
We are just checking up. But এখানে এর আগে আর কোনো ম্যাটার আছে? স্টেইটা কি রয়ে গেল? স্টেট 12 ডিসেম্বর না? স্টেইটা তাহলে এক্ষুনি হচ্ছে না। তাহলে এটাই প্রথম ম্যাটার হবে। 12 ডিসেম্বর করেছি ওটা কেন বলো তো? Mr. Shindra, how long would you approximately take? Just approximately to
Well, it's not much. If it will be supplied, my paragraphs will be indicated in my index. So not much, Malas, about
Just give the
an hour,
proportion and cite the
hour and a half. Yes, Malas, not more than that.
So
Hour and a half.
let me keep it on 21st itself. So I'll have the first half, at least a chunk of the first half. So
21st of this month, Malas.
this month, yes.
Malas, I am in a difficulty. I am in a Patchford on that day before the High Court.
28th, then because fixing it at 11 would be difficult because
We'll take our
I
chance,
have both
Malas.
the assigned and parted matters. So
No worries,
those
Malas.
is the first one now. If I take up some other matter, it would be difficult. I'll take it up at 10:30. I can take up.
No issues, Malas.
Thank you. The hardened part, the matter be listed for further hearing on November 28th,
Yes, Malas.
2025. November 28th, 2025.
I'm obliged, Malas. I'm
Thank
obliged for the patient hearing. I'm
No.
so sorry, Malas, if there was a slip of
Forget the years. নেক্সট কল করো আচ্ছা এটা ঢুকিয়ে দাও একটার সময় পর একটা বেঞ্চ আছে দুটো থেকে তিনটে এটাই হবে এটা নিয়ে কলটা করে দিন ইয়েস
Item number 8, Your Lordship. Yesterday, Mr. Sengupta at the rising of the court, Your
My
Lordship,
lord, I am appearing
mentioned-
for the petitioner in this matter, my lord.
mentioned the matter that Mr. Sengupta and Mr. Ray both have some difficulty that
My lord, he
couldn't
had
pick up
indicated
the-
that he will not be free up till 12:30, my lord, but I think it's already 1.
Yes,
We are
but
hoping that if
And the
they could
Miss-
continue with their argument since this matter has been pending
on the
for
last
long.
occasion,
Actu-
Lordship remembers that almost the whole day
Mi-
we have taken, and
Yes.
we need more 20 minutes or half an hour more to complete the
so
any day as per your lord.
first then 21st you're for the petitioner
I am for Calcutta Stock Exchange, Your
oh
Lordship.
you're right can go to us
No.
so we'll keep it on 21st
Right.
next
If it could be
when Mr. Mitra your
21st.
voice is getting cut off 21st yes
Lord, I appear for the petitioner. Very well.
your voice is getting
No
disturbed
difficulty.
21st
From
any difficulty
our side, no difficulty.
No, my lord, 21st is fine with us, my
My lord,
lord.
from fine, my lord.
voice is
My lord,
disrupted
My
show
lord, if
us in
this could,
sign language
my lord, 21st is okay with us if it just retain its position, my lord.
that's better so on the prayer of the respondent the matter is adjourned till adjourned for the day that means it's 21st
My lord.
My lord, I appear for respondent number 2. Anybody?
Just give your names in the inbox wherever
Yes.
I mean. Yes
Grateful, Your Lordship.
thank you দাঁড়া কেউ ডাকতে গেছে গলা পাওয়া যাচ্ছে
Lordship, in this matter, I'm for the petition praying for a short passover.
granted the matter is called on after the passover again we have granted and called on the matter again sir
Item number,
because this is the second last
item
one.
number
9 take your breath first
I'm praying for not today. Mr. Shuddha.
not today the petitioner on the prayer of the petitioner the matter is adjourned for the day 10 none appears for the parties at the time of call let the matter stand adjourned for the day তোমার প্রবলেম সলভ হয়ে গেল দুটো থেকে অ্যাপেলেট সাইড থেকে এখন রাইজ করে যাবো আবার এখন ওই বেঞ্চটাতে বসবো ক্যালেন্ডারটাও দিয়ে দাও যাতে হ্যাঁ ঠিক আছে
I'm obliged, Malas.
থ্যাংক ইউ কল করে দেখো আছে কিনা।
Lord, I am for the petitioner.
Yes, আছে।
My lord, before starting, my lord, I am humbly praying that your lordship's direction was to file affidavit in opposition.
Yes, Mr. Just let us see the previous order first. It shows in the nature of reconstruction. The petition shall be done at the repair.
Affidavit of service. Affidavit of service.
What was the matter? Just give us in a nutshell, Mr. Mukhopadhyay.
Now, in a first appeal challenging the final degree, we have taken out an application for repairing. Now, my lord, it has been mentioned in paragraph 4A of that application that the first floor roof has already been collapsed. And so we need to.
Sir, give this.
And we need to repair the room.
144 was issued and in contradiction.
My lord, yes, my lord was pleased to observe
Yeah,
that
but
you repair, but as regards the first floor roof, you take permission from the municipality. There was
even that repair was stalled by the one.
Thereafter, they moved, challenging that they moved the 144 court, and the learned executive magistrate has stopped the.
Yes, Ms. Vishas, what were you saying?
My lord, last occasion, your lordships directed me to file affidavit in opposition by 26th September 2025.
Yes,
But under,
individually by each of the allegement.
my lord, under compelling circumstances, the respondent number 1, being the father, he was seriously ill. He could not file the affidavit.
Respondent number 1 being the father means?
Respondent number, appellant number, respondent number 1.
Contender number 1.
Contender number 2, upon whom the direction was filed to affidavit in opposition by.
No, direction was on both contender number 1 and 2.
Yes.
I am appealing for the contender number 2.
What about 1?
Lord, 1 we have solved, but no affidavit we have received.
Respondent number 1 is the magistrate.
Magistrate. And
So executive magistrate.
yes, my lord.
So had to be served.
Yes, we have served. We have served. Lord,
Where is the track report that service has been effective?
track report?
Why didn't you file a
Lord,
proper
I
affidavit of
undertake
service?
to do it by the course of the day. Track report magistrate কোনটা দিকে এইটা তাই তো?
Service has been effective.
And can you give me 1 minute time, my lord? 912 item delivered. Yes, my lord. 912 item delivered.
দেখি আইটেম
Last
ডেলিভারি
one, 912.
রুল ইস্যু করব।
And my lord, kindly see the receipt 912.
Assignment number is same, right?
That is why, my lord, kindly see the receipt at the top. That is 912 is the magistrate. 912 second one is the magistrate, and see the
912 is not the yes, the magistrate.
the magistrate, and he has received.
You have to file this during the court.
Yes, during the
Submit
next
thing,
one
my
or
lord.
Yes, you what has happened to the respondent of 2?
Contender number 2, my lord. The
Yes.
son, being the power of attorney, my lord, has affirmed the affidavit in opposition. Since
Contempt, you cannot do that.
Yes,
I'm grateful.
Yes,
I'm grateful. That is the preliminary objection. I was just.
grant me leave.
No, in your order it was very clear, Ms. Vishwas, you ought to have advised your client.
Yes, my lord.
It was, we directed them to, no.
Kindly grant me leave by my
No further leave.
filing, my lord.
No. Individually by each of the alleged contemnants is very clear.
Yes, that is true,
The
my lord. But
contempt-
on that day, I was admitted in the hospital. That's why I could not affirm, my lord.
You were present on that date. Your client.
My client could not affirm the affidavit in opposition. That's why I am humbly praying, my lord, grant me leave to file affidavit in opposition. By Monday, I am filing. It is ready, my lord. Grant me leave, my lord.
Lord,
I
I do join issue here, my lord. My lord, first of all, the affidavit came after near about 1 month late. Second, my lord, this
am
this
submitting
proposal was given by learned friend, since I have specifically taken this preliminary objection in
When
the
did you become ill?
because it's a
Yes, my lord.
space.
When did you fall ill?
No
on
document. My lord, see me.
What? Wait a minute.
21st September, I was suddenly became ill, my lord. I am 68
We had given the
years old.
direction on 12th of September.
12th of September, within 26th September, it was directed, my lord. On 21st September, suddenly I am 60 years old. I was attacked, small time heart attack, my lord. That's why I was admitted, my
All
lord.
of us will soon be 60. So
My lord,
60 years old is not very attractive to us.
the age of 40, my lord, it happens, my lord. And it was continuing, my lord. I am admitting, my lord.
You are very prompt in filing the 144 petition.
I'm grateful.
And you are not prompt in filing
That causes this.
problem.
That creates my sufferings, my lord. My lord, kindly consider the situation, my lord. When the 144 was filed.
Learned advocate appearing on behalf of the takedown. Learned advocate appearing on behalf of the petitioner undertakes to file affidavit of service in course of this. Stop here. Learned advocate appearing on behalf of the alleged contempt number 2 submits before this court that she intends to file affidavit in opposition within 2 weeks.
By Tuesday,
Within 3 days.
yes.
He.
3 days, no, by Tuesday, my lord. Today is Friday.
In a
Within 3
he.
days.
She wishes to file affidavit তো এখন তো করব
আচ্ছা কেটে দিন
না না সব ঠিক আছে শুধু সেটা কি করব
full stop. Within 3 days, 3 working days from today.
Yes.
Stop there. None appears on behalf of the alleged contender number 1 despite service. Stop there. In view of such, liberty is given to the alleged contender number 2 to file affidavit in opposition within 3 working days from today after serving an advance copy of the same to the learned advocate for the writ petitioners. Full stop.
reply time
Affidavit in reply if there be any is to be filed within 1 week thereafter. Stop para. Since despite service none appears on behalf of the alleged content number 1. Content number
এখন রুল ইস্যু করিনি
alleged content number 1 let a rule of contempt be issued against the alleged content number 1 forthwith which is returnable after
made returnable after না on করে দিন 12 ডিসেম্বর রাখি নাকি 12 ডিসেম্বর
on December 12, 2025
at 1 p.m.
at 1 p.m.
12 December 1 p.m. In the meantime, you file within 3 working days, and Mr. Mukhopadhyay use your reply to that. And but affidavit of
service filed.
Yes. Today.
Unless you file the affidavit of service today, the next rule will be issued against your client or you personally even.
Yes, that is the high risk. I have to. I'm grateful, Lord. Hey,
Item number 2. I appear for the petitioner. Lord, I must be very candid, Lord.
That means you're in some difficulty.
Affidavit of service has been lost from my custody.
Lost.
I must be very candid.
May happen.
I appear for the alleged contender number 1 only.
And I served, Lord, I have prepared by.
Regarding two, we cannot do anything. Then we have
Lord,
one. You're filing your affidavit. There was a direction for filing affidavit. There was a direction.
Yes. Milord, the time was over, Milord, but still, Milord.
You have given a copy to them.
Lord, they have served copy.
So we'll extend the time for a.
But kindly
filing
condones that, Milord.
We'll accept this. But how long do you want to file a reply to this?
Lord, before going to this, Lord, I have filed one can.
What can?
Lord, can is that Lord, I know, Lord, apart from them, there were certain other persons who were also indulged in these activities for committing the contempt. Lord, this
So an
was
application
can
for
one.
what?
An
Amendment.
application for addition of those persons as the contemnor in my.
That is not appearing today.
Lord, this is appearing. I filed can 1.
The can't.
Lord, the supporting documents, Lord, I have also got.
It is a can 2.
Can 1, Lordship. Can 2 is in support of FMA.
Target. Can 1.
Can 1 of 2025. That is for addition of the
What is
development.
the nature of the alleged contempt?
Not the nature of the contempt is on page 21 is the.
Just tell us what
Lord,
you did. They did
Lordship
not
has
do.
directed from changing the nature and character of the property and also from.
So other persons are also involved in that.
Other persons are also involved.
But they're not parties to the main appeal.
Not.
But
The
knowing of
main
the order, they
agents
did that.
Lordship.
Knowing, despite knowing of the order, you say that.
Lord, I should serve them also. Lord, they should also be.
Serve a copy of this application along with the contempt application on them. And
Milord, we should also be served, Milord. We have not got the copies.
I am serving here right now.
Can 1 of 2025 is an application alleging that certain other persons than named in the contempt application are also guilty of willful and deliberate violation of the order of this court. Full stop. Accordingly, let a copy of Can 1 of 2025 be served on the learned advocate. You are serving, you have served.
Yes,
Right.
served.
Accordingly, a copy of Can 1 of 2025 along with the contempt application be served on the proposed added alleged contemners at the earliest. Push up. A copy of Can 1 of 2025 is handed over here and now to the learned advocate appearing for the alleged contender number 1 who files the affidavit in opposition of the alleged contender number 1, which is accepted on condonation of delay in filing the same. Push up. The time for filing reply thereto is extended for a week from the date. Push up. Next para. The contempt application along with Can 1 of 2025 shall next be listed on December 12, 2025 at 1 p.m. Because we have kept the other matter on that because yes, the in the event since learned counsel for the petitioner submits that the affidavit of service prepared by him has been lost from his chamber, comma, fresh service you have already directed on contempt number 2. Fresh service of the contempt application along with Can 1 of 2025 shall be effected on the alleged contender number 2 also at the earliest.
2 to 4, sir.
2 to 4. 2 to 4. 2 to 4.
Madam, Can 2 also. Not only Can 1.
Why Can 2?
But Can 2 in. Huh?
Can 2 nahi, Can 2 FM.
Let them come there. Thereafter we will start.
And a further affidavit of service, a fresh affidavit of service to the above effect shall be filed on the returnability.
That's
Complicated everything. E79. E79.
Section number 120.
79 paragraph. Well, I appear for the CBI.
CB.
State Bank preferred an appeal, and my lord, the division bench has granted stay of further proceeding.
Has granted a stay
Stay
of
of
this
further proceeding.
of this.
And on the subsequent hearing, State Bank also informed the Honorable Court that 2 other appeals have also been preferred. And those 2 appeals, along with this appeal, have been fixed for 15 December.
Well, then we'll keep it after in the January monthly list.
Yes. My lord, may I hand over the order?
It has been handed.
Possibly the petitioners are not coming.
That reason.
It is.
The learned ASG informs the court that in connection with an appeal preferred against the order of this court,
appeal by the bank, State Bank,
preferred by the State Bank of India, an order of stay of all further proceedings before this bench has been granted on September 17, 2025. Push up a copy of the said order dated September 17, 2025, passed by the division bench in MAT 1409 of 2025, is handed over to this court and is kept on record. Push up in view of the said order of the division bench, let the matter stand adjourned and be listed next in the monthly list of January 2025. Learned counsel for the parties are requested to apprise the court on the next returnable date as to the outcome of the appeal.
January 2026.
Oh, I said 25. They know, by now they have known. Thank
My lord, 4 may be taken because content. There was a rule, my lord.
3:30 p.m. fixed.
He is ready. He has come.
The alleged contempt has come.
Yes, and today's
Then I can take up right now.
3:30 resolution is there today.
Very good. ওটা 4টা কল করুন।
Please come.
Petitioner is there.
My lord, petitioner, my lord, is
then
compliance has been made and show cause to the rule.
Petitioner has to be there because the matter is fixed at 3:30.
And
if the petitioner was there, we could have taken up right now.
There is a resolution, my lord, today at 3:30.
So what?
Bar resolution.
Contempt is much more serious than bar resolution.
And that has to be, my lord.
And we sit till 4:30. If nobody appears, then it's different. But in contempt, you have to be present. If the petitioner, you should have informed the petitioner, then we could have taken up the matter. Anyway, we'll take it up at 3:30. No, not now. They may have something to say regarding compliance.
We are contacting, my lord.
Yes, if you can bring her before that, before 3, because 3 we have a pre-judgment.
I will try to assist you, lord.
Yes, whenever you can. The 5 to 6? 5 to 6, yes.
My lord, I beg to appear on behalf of the petitioner.
Yes,
Just to
Mr.
kindly
Pothuwal.
recall,
Yes.
my lord, this is relating to that, my lord, Shastha Bhavan driver. On the last occasion, they, my lord, handed over a compliance report. Before that, my lord, instead of considering the whole entire period, they have decided, my lord, to consider only 5 years. Lordship was kind enough to direct them to consider once again, to consider for entire period.
Now
Have considered. Now, what happened, my lord, they have calculated only on the leave and group insurance calculation, totaling 16,000 handed over, my lord, pursuant to the direction of this honorable court before 16/26/9/2025. Now, my lord, we pray for, my lord, after examining their second round compliance report, we requesting, my lord, the contemner as well as the lawyer, my lord, to supply certain document. My lord, this is our objection to the affidavit in compliance. Lords, if that, my lord, document in the event they have supplied, we can calculate it and be satisfied that they are on the right path, we are on the wrong path.
You have given a copy of this?
Copy of it. But that order may kindly be given on page 5, may kindly be looked into what we pray for from them. That is our letter addressed to learned advocate, addressed to 2 contemner. And my lord, this is, lordship will see, my lord, page 6. Calculation, PF calculation data, copy of service book, gratuity calculation sheet, HRA, copy of pay fixation order, calculation sheet of death and gratuity, rear family.
Go into it so much in contempt.
No, my lord, only thing, my lord, they are trying to avoid the whole thing. Lordship, kindly recall they have considered for 5 years instead of, my lord, 21 years. That being the situation. And now, my lord, they have handed over all these documents to the accountant general. My lord, we are praying, my lord, a copy may kindly be supplied.
No.
One more date, my lord, is
one thing.
Lordship.
What was the direction? That
Direction was, my lord,
interpret. Now they've given for the entire period. They are saying they have given for the entire period.
no, my lord, they are only calculated, my lord, leave and, my lord, the insurance. 16,000 for the total period. Neither gratuity, nor PF, nor other, my lord, things, nor provident fund, nothing of this sort. They wrote a letter addressed to AG that is kept pending before the AG, and they have
a
relied
written
upon
objection to the affidavit in compliance filed on the second instance of compliance, comma, on behalf of the petitioner, comma, be kept on record. For sub next para, a copy has been served.
Yes, my lord.
Have you got the receipt?
Yes, my lord. This is the receipt.
No, you should have taken a separate receipt.
No, my lord, this is a lawyer, and my lord, at the same time, the letter which you have sent, they have received it.
No, you, don't do this. You, serve it by a.
When the lawyers are appearing, my lord,
The lawyers are appearing. We always serve
Yes,
with a
my lord.
forwarding letter and file that in court. When it's on the client, then it's an affidavit of service, not on the body of the petition. That used to happen 20 years ago.
Lordship, maybe
Now we
I have
forward it by
committed
way of,
mistake.
because they're not appearing. How do you know this?
We have committed. But Lordship was kind enough to fix this particular.
Copy thereof will be served on the learned advocate for the alleged contemners by tomorrow, and by at the earliest, and a receipt be filed on the next returnable date. Full rejoinder thereto shall be filed, comma, if any, comma, by the alleged contemner by the next returnable date. Full the matter shall next be listed on November 28, 2025. Full since the ambit of the written objection is primarily to seek certain documents from the alleged contemners in order for the petitioners to ascertain whether there has actually been due compliance of the order of this court, comma, in the event the alleged contemners furnish the alleged contemners are able to furnish copies of such documents as sought by the petitioners, comma, the alleged contemners are at liberty to furnish the same to the learned advocate for the petitioner.
Lords, thank
you.
Deeply
You can serve a copy of this order also.
Deeply obliged. Deeply.
Yes, Mr. Bhattacharya.
Kindly, your lordship sees the last order.
I have dispensed with the appearance of the personal appearance.
Yes.
Oh.
Last day also they did not appear. 7th of
Yes. This is the second occasion after November 7, 2025, when none appears for the petitioner. Push-up accordingly. Your stand is that you have complied from your end.
From our end, I have complied. We have written to the foreign department.
Achha.
And as of now, my lord, the contempt application or rule has not been served. We are appearing, my lord, voluntarily.
Oh.
Because state government over telephone informed that this is the contempt. Then they, my lord, out of afraid.
Accordingly, WPCRC 133 of 2025 stand discharged, and CPAN 699 of 2020 stands dismissed for default. No arrest to cost. Next.
Our appearance.
Yes, give your obvious. Yes, they are filing an objection. They have asked for certain documents from you. We have permitted you to produce those documents if you can, in the meantime, or file rejoinder to that. We have kept it on 28th.
Lordship, may I give my name?
আমি কি রেকর্ড করেছি নান অ্যাপিয়ার্স তো রেকর্ড করিনি Yes, please give your name.
Grateful, you know.
Thank you. You're appearing in the... He's with you.
Yes, he's with me.
ডিস্ট্রিক্ট জাজ রিপোর্ট ফাইল করার কথা ছিল তো, সেটা কোথায়? This court had directed the district judge of the concerned court to file a report as to why the trial court records have not yet been arrived and not yet been received. Full stop. However, there is no office report in the files to indicate that such order was communicated to the learned district judge concerned. Full stop. The office is directed to immediately communicate this order to the concerned learned district judge, calling for such report. Full stop. The last date for filing such report is fixed at December 12, 2025. Full stop. The office is it is expected that the office shall be more diligent in making the communication at the earliest and filing a report in that regard on the returnable date. Full stop. The matter shall next be listed under the same heading on December 19, 2025. এটা অফিসকে দয়া করে বলে দেবেন, যেগুলো ডিস্ট্রিক্ট জাজের কাছে কমিউনিকেশন থাকছে তাহলে অফিস বুঝতে পারবে না। গাধার মতো এক রিপোর্ট দিয়েছে, আবার যে ওই রেকর্ড ট্রায়াল কোর্ট রেকর্ড আসেনি, একটা লাইন it is found from the office report of the assistant registrar Roman 9 dated November 11, 2025 that Tolobana costs have not been filed by the appellant. Full stop. As a last chance to the appellant to put in the Tolobana and requisites, the time for filing the same is extended till December 5, 2025. Full stop. In default, the matter be placed in the list under the same heading on December 12, 2025. Previously, the office has given an erroneous report which has been admitted in the further office report dated November 3, 2025. Full stop. Next para, it transpires from the order recorded on April 12, 1978 that in terms of the order dated March 22, 1978, in view of the non-compliance of the order dated March 22, 1978, the appeal stood dismissed for default on April 12, 1978. Full stop. Accordingly, no further order need be passed, since the appeal has already been dismissed for default, dismissed for non-compliance of the court's order. Full stop. Let such disposal of the appeal be recorded in the CIS of this court, Computer Information System of this court, CAPSE. None appears for the parties at the time of call. As a last chance to the appellant to argue the appeal, the same is adjourned till November 28, 2025.
Number 12.
The office shall call for a report from the concerned district judge as to why the records have not been sent to this court vide memo number 5059S capital S dated September 4, 1969, immediately. Full stop. Such report shall be filed by December 12, 2025. Full stop. A report in that regard shall be filed by the office. Full stop. The matter be listed next on December 19, 2025. এটাও একই অফিসকে বলবেন কমিউনিকেট করে দিতে ডিস্ট্রিক্ট জাজ। Despite repeated reminders, the trial court records have not been received before by this court. For the next para, the office shall communicate to the concerned district judge, calling for a report as to why the records have not yet been sent. Full stop. Such report shall be filed by the district judge by December 12, 2025. The matter will be listed on December 19, 2025. Full stop. The office shall furnish a further report accordingly. এটাও এক কমিউনিকেট টু দ্য ডিস্ট্রিক্ট জাজ। সব ডিস্ট্রিক্ট জাজকে যেন ইমিডিয়েটলি কমিউনিকেট করে দেখে নিয়ে কোন ডিস্ট্রিক্ট দেখে নিয়ে ডিস্ট্রিক্ট। None appears to move the appeal. As a last chance to the appellant to argue the matter, the same is adjourned till November 28, 2025. None appears for the parties at the time of call. As a last chance to the appellants to move the matter, to argue the matter, the same is adjourned till November 28, 2025. Since the appeal was compromised as recorded on April 19, 1966, the appeal bearing essay 1351 of 1965 stands already disposed of. Full stop. Let such disposal be reflected in the computer information system of this court. Next. Dispose of হয়ে গেছে চারজন না আছে নামিয়ে দাও। None appears for the parties at the time of call. Let the matter stand adjourned till November 28, 2025 as a last chance to the appellants to argue the matter. Argue the appeals. Plural. None appears for the parties at the time of call. As a last chance to the appellants to argue the matter, the same is adjourned till November 28, 2025. যে লাস্ট চান্স দিচ্ছি পরে আবার দেখিয়ে দেবেন একবার ডিসমিস ফর ডিফল্ট।
Number 20.
Same.
Number 21.
Same.
Number 22.
Same. যে কোনো একটা দিন। একই প্লুরাল করে দেবেন, অ্যাপিলস। On October 24, 2025, an adjournment was sought on behalf of the petitioners who served. However, on October 31, 2025, when the matter was next called on for hearing, none appeared for the parties at the time of call. FUSAP accordingly, as a last chance to the petitioners to move the matter, the same was adjourned till today. FUSAP even today, at the time of call, none appears for either of the parties, nor is any adjournment prayed for. Accordingly, CPAN 1583 of 2023 is dismissed for default without any orders to cost.
I am for the petitioner, my lord.
30 to 40, my lord,
Those matters.
Insurance matter, my lord, on the last day, your lordship directed, my lord, the insurance company, Mr. Abrutus Mujumdar, senior counsel, was appearing, my lord, to make a state government a party, my lord, to amend the cost title, making the state a party and to serve upon the state. My lord, I have filed, may I file my affidavit of service, my lord, these 11 matters. My lord, I have made correction in my lord's cost title, my lord.
It is appearing today.
My lord, state.
So far as I beg to appear for item 31 and 34.
What
My lord,
about
I am for the.
For the state, I did responded.
I am for the petitioner, my lord.
You are for insurance.
So what is your, why was the state sought to be involved?
My lord, since it is not an adversarial, my lord, litigation,
Yes,
my lord,
yes.
it was submitted before your lordship, my lord, and the state was a party, my lord, in that is.
Bangla Shosho Bima is the issue, whether the
That
cultivator
no longer there.
is there, but why they have not been given, that is the issue.
So
Because
you have to-
bank has failed to remit or transfer the premium on time to the insurance company. That's why they are unable to settle it. Because here bank is the answering as because it's a case of loany cultivator. When loany cultivator goes to take loan from the bank, then bank will have to give the entire loan to the petitioner cultivator minus the percentage of premium which subsequently has to be
What can be
transmitted.
done, Mr. Khalid? Can a relaxation be given to these people, or because they have already
No, the
applied?
lordship by the parent order had given the liberty to the bank, asking the insurance that you give the mercy of the delay caused by them and do it. So therefore, thereafter, Miller insurance company came and filed a recalling application saying that this way it cannot be done because there is no question of extension of time in the scheme as contemplated. So we can't do it. Moreover, on the self-same issue, there are already 2 reasoned orders passed by the authority concerned on the in compliance with the order of coordinate bench, where Milord bank was fastened with the liability that yes, you did not do it on time, it is your responsibility. Because loany bank means it is between you and the cultivator and the insurance company.
The bank did not forward in time. That is the allegation.
And in that reasoned order, bank was fastened with the liability. And whether that reasoned order is under challenge or not, I do not know. So if that
The recent order was challenged and by a coordinate bench of this honorable court, the honorable court directed that again, a scheme should be framed so that the petitioner could not be deprived. I have annexed that order.
it relates to the same district, same bank.
Where is that order in your?
Lordship, in my opposition, recalling your lordship will get that order.
Bank your opposition. You are for which bank? Miss PNB opposition director.
My matter, item 13, Industrial Development Bank of India, Bishtapur branch.
Reasoned
order,
order
lordship will get from the recalling application also. The 2 reasoned orders are annexed to the recalling application.
Not the reason order. Ms. Rajudri says that there is an order of the court also.
Of court's order.
Lordship,
Insurance company বলছি না bank PNB
Opposition to the contempt application your lordship will get. Lordship, that is at page number 14.
নিচে নামো নামিয়ে দেখো খোঁজো which item number what is the CPN number
1991
1991
1991
1991 এ দেখো
of 2024
ব্যাংকের অপোজিশন আছে
ব্যাংকের opposition contempt application হ্যাঁ
এটা তো ক্যানের অপোজিশন is just a shortcuts order
petition by strength of your lordship's order so that the bank can get the same order so that the farmers my lord may not be deprived. My lord will see the operating part of the order will be at page number 16 your lordship.
16 there is no 16 no আরেকটা
কোথায় বললে এই না এই অর্ডারটা তো এই অর্ডারটা কি চ্যালেঞ্জ করলো ওরা? হ্যাঁ ব্যাংক
16 yes 16
My lord get that. My lord will see third last paragraph the right of
Where is that order?
have already been upheld by the principal secretary my lord which was the order impugned there. The scheme also includes a crucial role by the state government. Secondly, NICL cannot ignore the order passed by the Principal Secretary Government of West Bengal Department of Agriculture by remaining quiet and by not cooperating with the bank. Thus, the direction made herein should be complied with by the authorities and the farmer should not suffer at the hands of the non-compliant authorities. The inaction of the bank and the NICL cannot be encouraged. The court cannot understand why NICL could not rise to the occasion and abide by the order passed by the Principal Secretary, Department of Agriculture. The farmers shall serve a copy of this order upon the Principal Secretary, Government of West Bengal, Department of Agriculture, Law and Vigilance Branch and NICL so that the state authorities can monitor the compliance of this order by the bank and the NICL. The farmers cannot suffer on account of any mistake of the authorities. NICL has received the premium and they cannot indulge in unjust enrichment. Thus, the writ petition is disposed of. My lord, we have forwarded this order along with your lordship's order again to the NICL, my lord, so that something could be done. My lord, I have annexed all the orders. My lord, these are there in my affidavit in opposition.
so even if it is not in the scheme Mr. Mujumdar, you are for the insurance company
Yes, my lord.
even if it is not in the scheme under 226 coordinate bench has directed the NICL to
Perhaps there
comply.
is a distinction subject to lordship's kind consideration.
Premium was transmitted. You have time.
Scheme was there at the relevant point of time just due to
Yes, the
banks non-compliance.
The premiums were transmitted in that case.
But here it is not.
My lord, we have in our this affidavit in opposition, my lord.
May I get a copy? I
No, no, may I just kindly keep it next week? May I go through and come back to your lordship with the appropriate instructions?
Because even if they have, we can put something in the order that even if they have belatedly given the premiums, you honor the scheme and give, because ultimately that will be sponsored by the state.
Yes, my lord.
Ultimately, that is to be sponsored by the state.
4 point, that is certain percentage, 4.8 something.
No,
Some
only
percentage premium is to be given
you
by bank, rest 10% will be given by the state.
Get to your lordship, subject to lordship's kind consideration.
No, what is
But
the job of the insurance company then?
Insurance company,
my lord, the whatever amount is to be paid, that is protected by an insurance policy. That is the only job. Subject to correction by all my.
What is the role of the insurance company now regarding the disbursement?
My lord, suppose, my lord, the disbursements are to be made through the bank, the remittances.
What was the modality? The bank was to pay to you the premiums.
The modality, my land friend would bet. Modality is that, my lord, when there is this kind of, my lord, this kind of event which takes place, there is a time limit within which, my lord, the incident has to be reported.
No, the modality means the modality of the entire scheme. I mean, bank will pay to you the premiums.
The route of payment.
Route of payment is bank will pay to you the premiums in time.
Yes.
And then you will pay this insurance, disburse this insurance amount when necessary.
When necessary.
Well, we will collect it from
Yes.
the farmers.
There is a cut-off date.
You will collect it from the farmers. They have paid in your case.
We have deducted from the farmers, my lord. There was a technical glitch, my lord, for which we couldn't.
You could not forward to the insurance company in time. So if they give the premiums to you now, then
The only
lot of
difficulty is
time
that,
they will
kindly
ask you to relax.
give me some time. Let me go through. I should not be making any statement today. Keep it next week, week after, whichever date suits your lordship, my lord, I will come back. Let me go through, my lord, let me examine the order passed in the other matter. Let me also examine what is the stand taken by the bank, whether the stand is at all, my lord, is a tenable stand in the facts of this case or not, that I will make submission.
Learned counsel for the bank.
May I get a copy of the
Punjab
opposition?
National Bank relies on an order dated August 1, 2024, passed in WPA 2344 of 2024 by a coordinate bench, whereby under a similar situation, it is submitted, the National Insurance Company Limited was directed to comply with the order by and the state authorities were directed to monitor the compliance of the order by the bank and the NICL. For sub next para, the conspectus of the contempt applications is a direction by this court for the insurance company to honor the insurance, the disbursals in favor of the farmers under a scheme floated at the behest of the state government. First up, the bank was to pay the due premiums to the insurance company, and the insurance company was subsequently supposed to honor the scheme. First up, in the present cases, however, the bank, apparently due to some technical glitch, could not uh, meet the commitment of payment of the premiums in time, for which the disbursals could not be made in favor of the petitioner. First up, next para, the endeavor of the court is to ensure that the order of this court is complied with and a relief is given to the petitioners, who are cultivators by profession. First of next para, learned senior advocate appearing for the insurance company, National Insurance Company Limited, at this juncture submits that he may be granted some time to peruse the order relied on by the bank and the other materials on record, as well as to take appropriate instructions. First of next para, accordingly, the matter be listed on November 28, 2025 under the same heading. For the next para, copies of all affidavits be exchanged in the meantime and among the parties. Please, whatever is, Mr. Kali, whatever have not got, just intimate them. The bank
I
can.
will also come back with appropriate instruction where we will
Please
try
come
to
back with
we will try to resolve the issue.
Even if they belatedly pay it to you, then if you can honor it, if there's any scope, we can make it a direction of the court.
Yes, ma'am.
Because it will be a one-time thing only.
Well,
We cannot make it a precedent. Otherwise, all insurance companies will stop functioning.
Otherwise, my lord, some scheme
No,
has
this
to
cannot
be
be
for the insurance company for their service.
Right. Thank you.
Till 40 same matter, my lord, 30 to 40.
30 to 40 same order. Thank you. একসময় তো হচ্ছে না বোধহয় আলাদা। প্রথমে একটা লাইন অ্যাড করে দিন, all the matters are taken up together because of identity of the causes of action করে দিয়ে বাকিটা করে
I'm the petitioner on this case.
Yes.
Staff revenue service, my lord. This is my revenue service, my lord.
Good service has been affected.
Yes.
No. Where is good service? Item delivered as a Salad SO.
Yes, my lord.
Salad SO is their address.
Yes, my lord.
This is regarding only one contemner.
Yes, my lord.
What about the other?
Only one contemner, my lord.
There is only one
Your
contemner.
direction is only to Panchayat Pradhan.
Ach. Why two? One receipt only.
Yes. 41.
What is the order which has been violated?
My lord, you just directed the petitioner to approach the contemner, alleged contemner, to go through what they actually their grievance.
So they have not.
No, my lord.
You went there. What is your allegation here? That you went there, but they did not.
Yes, my lord. I personally didn't went there, but I
No, not
sent
you.
this.
Your client.
I sent notice with this
Notice.
order, my lord. Later, they petitioner went through along with the other villagers to her, but she did not bother. She said, we do not bother the order, and whatever they are doing, just let them do, and just threw him out from the office, Panchayat office. Then on that the same day, my lord, the petitioner and other villagers went to the police station with this order, my lord, order, and the police station said,
Despite affidavit of service filed today, be kept on record. Despite service, none appears for the alleged contemner, comma, nor is any adjournment paid for. Full stop. Since a prima facie case of contempt has been made out, comma, a contempt rule be issued in terms of the prayers made in the contempt application, comma, which is made returnable on December 19, 2025 at 3:30 p.m.
December, my lord.
December 19, 3:30.
19,330.
Next.
Much obliged. And it pen down on the pen and the pen.
You don't have a pen, you're an advocate. You're...
I just forget and just have it in my bag. Sorry, ma'am.
But she won't be able to take down my orders then.
My lord, please. It is my bag, my lord. By mistake, I forget.
Quickly.
Yes.
My lord, I appear for the alleged contemners. My lord, I am led by Mr. Abhrojit Mitra.
Well, I couldn't run. Suddenly it collapsed so fast, I couldn't make it. I'm very sorry. But
there was a bunch of matters actually. Yes.
Yeah, that's why I thought I'll run, but then I will not be able to make it. That's why I've joined.
What is the nature of...
Your Lordship, on the last occasion, Your Lordship had directed on 18 September to serve the alleged contemners. Your Lordship are also directed to file affidavit of service, but there was one issue is that one of the contemners, the package had returned back. So I was just trying to figure out where the address, I believe it is defendant number 9, if I'm not
Mr. Mitra,
7 or 8.
you are appearing for all the alleged contemners.
One of them was returned back, Your Lordship.
Which one you don't know? Where is your affidavit of service?
Defendant affidavit of service was yet to be filed because I wanted to serve the entire and then file the affidavit of service. So
No, whoever has been served, you file an affidavit of service regarding them. At least we can take up the matter against them.
Your Lordship may kindly make
Regarding
it
the
not
others,
today.
we can issue a rule if they don't appear then. But
all right, Your Lordship may kindly make it not today. I will, sir. I will.
If they are appearing for all the alleged contemners, then
Who are we appearing for? Can you please indicate to the court?
He's trying to indicate to himself first.
My lord, I'm sorry, I could not file the Wakalatnama also. So I am told that we are representing for all.
On the prayer of learned counsel for the petitioner, the matter is adjourned till November 28, 2025 to enable the petitioners to file an affidavit of service. We are putting it at that because we don't know whom we are appearing for. So make sure who we are appearing for.
My lord, may I give our names?
That is what we are thinking. Very well. Leave is granted to the advocate for the alleged contemners, comma, appearing in court today, comma, to file their Wakalatnama in the meantime.
Grateful, my lord. Grateful.
So give her praise. Yes.
Grateful to her.
But file it immediately, whatever Wakalatnama you have.
Grateful.
And indicate to her also whom you are appearing for. If you are appearing for all, then she is saved of them. The parties have been consistently unrepresented when the matter has been called on for hearing on previous occasions. On October 31, 2025, a last chance was given to the appellant to argue the appeal. Next para, even today at the time of call, none appears for either of the parties, nor is any adjournment sought for. Accordingly, SA 1495 of 1965 is dismissed for default without any orders to cost. Interim order is, if any, stands vacated.
We are expecting a similar situation as the last matter. I was summoned from Eden Gardens.
From Eden Gardens? Why? What happened? Last matter is which last matter?
The last order. Yeah, otherwise we would have suffered the same fate.
Dismissed for default?
It would have.
So this is 2020. That was a 1965 appeal.
65.
These 65 appeals are listed for this purpose.
Oh.
Yes.
Milord, your lordship's pleasure was that we should
My lord,
prepare a note.
my lord, Mr. Orijit Chakraborty is appearing for enforcement directorate. Due to his personal difficulty, he could not present today, my lord.
What is the challenge against Mr.
Milord,
Chaudhary?
this is
For
under
note of argument.
Yes. Your lordship had done in the last occasion, on the last occasion said, principal arguments are recorded in the ad interim order.
Oh,
we should file,
that matter.
yes, we should file anything additional or put a note to put an end to it.
We'll give you a last chance, it is a last chance. You file your additional written notes of arguments on the next day.
Fine.
We'll keep it on 28th, Mr. Chaudhary.
Yes,
You are filing the written notes today.
yes.
The
Here we not one simple argument. I'm going to put
Yeah.
my learned friend on notice. This is an act without jurisdiction. I am not an accused. I have, even as per the order, I am not an accused. I am a company whose land has been attached. Now,
you are the company and some of the directors also.
yes, some of the directors, but principally I'm the company, because directors really have no right in my assets, petitioner number one's assets. So, my lord, what has happened is two brothers, Ramesh and Mahesh. I am Ramesh. Mahesh has, my lord, entered into a fraudulent transaction. There's no love lost between us, litigating everywhere against each other. Now, he, my lord, obtained some LIC policies, didn't pay the premium. On the strength of the policies, took 22 crores out of Allahabad Bank. So, my lord, CBI went after him. Now, that's good. But based on that predicate offense, Section 8 order for provisional attachment done by the ED. I have no problem with that also. Please proceed against him. It will help me, because then he won't concentrate on his litigations against me. But fact of the matter is that ED, after recording everything regarding Mahesh, leaves his 1,000 crore companies aside and attaches petitioner number one's asset.
No,
Because he's a shareholder.
Shareholder, yes.
But he's actually not a shareholder, because between Mahesh and Ramesh, there was a family settlement in 1996 and 2002 in the presence of father. Petitioner number one has come to Mahesh. Hey, I'm sorry, Ramesh. And he, I threw him out of the company naturally. He went to company law board and it's been held. He has no rights. Father may have had some rights, but his shareholding is wiped clean. The transfer in my favor is upheld. So he has nothing. B, in any case, shareholders, even if he's a shareholder, based on his shareholding, assets of the company cannot be attached. And what the ED has done is, ED has made a calculation that Mahesh had 1/3 share, 25% shareholding, so 1/4 of the land belonging to the company will be attached. This is, my lord, legally erroneous.
So these were discussed in the order?
The ad interim order.
These were discussed?
Yes.
So that is the 26th of September?
2022.
Yes.
And so it's an act without jurisdiction completely. I am not concerned with the ED or his dispute.
So whatever order was passed at the ad interim stage, you would be satisfied with that?
It's a confirmation. And I have also filed a writ petition asking the ED that if at all you are interested to proceed, please proceed against Mahesh's assets. And I've given information about his 1,000 crore
What
company.
have you added here? I mean,
really nothing added.
So you have just put that on
Just
in
put
a structured form?
Yes, my lord. With the page numbers for consideration.
I'm sure. You relied on certain judgments also, which were discussed in that.
Yes, my lord, because we have added the
Bachagazdar and all regarding shareholder, the shareholder having no rights.
Yes, Bachagazdar,
That is
leading up to, my lord,
yes, Priyambada.
Berlia, because he might come and say family company. Berlia is the only judgment which says whatever you call it, family company or not, the principle that shareholders have no right in respect of the asset, that continues. So that's Berlia, and this is the ad interim judgment, my lord. In fact, your lordships considered the matter at the interim stage. Shitanoni.
The other judgments must be somewhere on.
My lord, with my lord the Honorable Chief Justice Mr. Justice Shivagyanam and your lordship, my lord, delivered a judgment in the Birla matter. That
you have handed, no.
Yes. No, this is the ad interim order
These
of
are-
that judgment. And that judgment is.
No, the other judgments are already on record.
No, I'll just bring that.
No, they are there. Previously, you had cited
Yes,
that's why
yes, yes. At the ad
those were
interim
recorded.
stage.
Yes, yes.
My lord, I'll make a compilation and
Judgments are here. Need not make a compilation. What are the judgments you are relying on?
No,
Just
Mr. Ram.
I'm just
yes.
telling you the names of the part. Just tell me whether these are there is something else. One is Kaushalya Infrastructure. This is 2022 SCC online.
Not go. That is ED's alternative dispute.
Oh, sorry, that
argument.
is by the ED.
Yes.
Your judgments are one is
My lord,
Opto Circuit.
Bachagazdar.
Bachagazdar, forget it. One is Opto Circuit India, that is 2021 6 SCC 707.
My lord, 2021 6 SCC.
707.
I'll just check the citation, my lord.
Several
Yes,
judgments.
this is Opto Circuit. This is also
Opto Circuit.
freezing of bank accounts, etc. I'm not on that because I'm going to proceed on without jurisdiction. Because you can attach assets.
Bachagazdar is there.
Yes. My lord, I'll just then rely upon, my lord, if your lordship sees paragraph 11 of my lord's interim order, all the judgments are
The
there.
judgments have been referred to.
Yes. So those, my lord, are what I will
Very
be
good.
relying upon. And I'll proceed solely on the ground, act without jurisdiction, because you either have to show money trail,
Yes.
nobody's case that there is any money trail, or you have to show this is asset of the accused. That also, my lord, nobody's case. You rely on a principle which is, my lord, fallacious, because you go to the shareholder who's the accused, and you have a right to attach his assets. I agree, you have a right. But assets of the company are not his assets, so you can't touch them.
Added respondents were.
I appear for the added respondents.
You have to add something.
Yes, I will, and we have already preferred an appeal, the statutory appeal from this order. The provisional orders which
From
are
the
the challenge.
ad interim order.
No.
Oh, from the
provisional order, then the final order came in. The final order is also and we have appeal pending.
Scope is entirely different in so
But there is all the appeal pending. Provisional order is challenged before
in addition, you are Mahesh.
He is Mahesh.
Yes.
So Mahesh has to
Lordship has heard this matter
himself.
Mahesh has to be heard.
Yes.
Mahesh has to be heard.
Mahesh has to be heard, of course.
So they moved this without making us a party. We came in for an addition of party, added. Initially, we
asked ED to do that. They'll happily do that.
Yes,
They'll add you as a party everywhere.
Everywhere. They attach my properties, everything. That's the thing that
Well,
the
it's
appeal is
like
pending. I'll take that.
If I sit down to eat and I see there's an empty plate and there's a full plate, I ignore the full plate and start looking on the empty plate. Why would I do that? This is what the ED is
because
doing.
it belongs to my neighbor. Obviously, that will be more interesting than
maybe they were prompted, Willard, for some reason.
As persons.
I know.
Mr. Chakravarti has to be there too.
Yes. Otherwise, there's no joy in making this statement, this argument. And
This
it's
is
not
aim to ED.
Sadism is lost.
Yes, this is aim to ED, not to me.
No.
From Monday, my lord, from Monday till, my lord, the day when the matter is heard, I will, whenever I see him, I will tell him, remind him that.
We will give you 2 weeks to do that.
Yes.
Because next week, court mila is early, a bit early. There is some difficult. So we'll start hearing you now. You have 9 minutes because we have a special bench after that. You can continue after that special bench if
Mr. Chaudhary will continue.
Mr. Chaudhary has because he relies on his initial arguments and he has filed a short written notes of arguments also.
No, so far, preliminary thing what I say that whether it is without jurisdiction.
We'll invite written notes from you also.
Yes, I know.
Brief written notes.
I will. Only the points, broader points, my lord. Whether it is without jurisdiction or it is the money trail. Now, today, the provisional order of attachment is under challenge before the writ court. One day before this order was passed, the final order was passed by the ED authorities. And there's a statutory appeal which I have availed and which is pending.
So, do you say this has become infructuous?
Why I say, my lord, not to that extent, there can be a conflicting decision. Because the entire order...
This was prior then.
Yes, this is prior.
An appeal has been preferred that does not,
No, but the final decision, because the provisional order merged in the final, and the final is challenged in the appeal.
It's true, but if the provisional goes the other way, if you see from the other end, if the provisional order goes, then it may have an effect on the final order also.
Final order. Then the question, which I will answer,
because here in
whether
this particular
then what
under this
happens
act, provision final order is dependent on the provisional order also. Is it? We'll have to look into that.
Must be.
We'll have to look
Then
into that.
if
Otherwise,
the
it has merged.
provisional order goes, then the final order also goes. Then the question is what happens to my appeal?
It
And
also
whether
becomes
that
infructuous.
also goes infructuous.
If the main order goes, then you win
Then
the appeal.
yes, then my appeal also gets infructuous. Then my appeal gets
You
infructuous.
should be supporting me in that.
Your appeal gets allowed then.
My appeal gets allowed, because my brothers Ramesh are
want to win.
No,
Brothers in
what
arms.
will happen. I don't know what will happen, but you winning it here.
This is not Ramesh and Suresh.
No.
As in the
That is Milord
the advertisement.
R.P. Arilal.
No, that is in the advertisement.
Oh.
You are enamored with.
No, I don't watch TV at all.
No, I used to watch up to Ramesh Suresh. That was probably one generation back. So after that,
we have actually never.
I forgot which.
Yes, we have actually, Milord.
They came in different dresses and as if they did not know each other.
We've never had access to television.
Never had access to
Never.
television.
Milord, when I was in school.
That's why you are such a good student.
No, I'm very bad student.
That doesn't apply to me because I was a bad student because I had full access to TV.
No, but in our hostel in Pune, there was no TV.
Oh, Pune, yes.
So we had no access to TV. And after we passed out, Mr. Mitro's chamber, Milord, he's an antithesis to television. So actually, we've never had access. And when I was till class 12, Milord, Star TV and all had just come when I was in class 11. So when I started watching, went off to Pune, no TV, no access. Then Milord, Mr. Mitro's chamber.
So you come prepared with come prepared with the short written notes of arguments as well. We will hear you verbally also, no difficulty, and ED also same. An adjournment is sought on behalf of the Enforcement Directorate. For sub next para, brief notes of arguments filed by the petitioners be kept on record. Full learned counsel appearing for the added respondents and the ED are requested to come prepared with the brief written notes of arguments as well as advance oral arguments, if any, on the returnable date. The matter shall next be listed under the same heading on November 28, 2025, week after. ভালোই হতো তোমার ওই ঝামেলাটা রইল।
At 3:30.
Yes, the petitioner is still
not available. The contemner is here. So at 3:30, if his personal appearance, at least today, this is the second week consecutively. Last week.
Yes, last week I was not there.
Yes. So if Lordship may come.
But before 3:30, can we do that? That is what.
I have been constantly trying to get in touch with the petitioner's advocate. She's saying she's not even in court. She's on her way. So I presume it's going to take
Then
some
please
time.
ask him to wait till 3:30.
That I will.
Because it's printed in the list 3:30.
That I will.
And we printed 3:30 because of the convenience of the alleged contemner, in fact. Because he or she will know when they have to come.
Grateful, Lordship.
That is the reason I fix times for when rule is issued.
Yes, Lordship. I just want
The
to
only
correct-
reason.
Just
But
want
now I am a prisoner of that. Because you don't know when the special bench may continue for 2 minutes or may continue for some time.
But then we'll wait.
Please ask, since he has come, I requested the alleged contemner to be present whenever, I'll take up the matter as soon as possible.
Lordship, that's all I wanted to know.
I'll definitely take up the matter. I have to take up.
Great.
If not at 3:30, I cannot, for some reason, the bench continues. Today itself, I'll be taking that up before rising.
We will wait.
Definitely. Yes, what do you?
Why your lordship will be taking up contempt matters?
That's a suspense.
My lord.
सबका मैम हो जाएगा समझे ना। साहब का हो जाएगा बताइए ना, में तो साहब बैठेंगे, संपा मैम है उसके पास। हाँ हाँ ऊपर से मैं
Yes. Revisiting the same thing.
Let, I presume
Justice Sarkar actually is a arbiter now. Because you have
Third umpire.
My lord, Justice Sarkar actually reminded me that the matter is
এসব
here.
ভুলে গেছিল তো আসতোই না
That's why I asked my PAs to remind their PAs so that they don't forget. But they remembered.
And look at the other side also not here.
So you can just formally start because there's a direction of the Supreme Court.
I don't know that. What happened, my lord, before the Supreme Court, because the matter was there, my lord, before
that was the that was what prompted us to fix a date quickly because there's an observation by the Supreme Court to be heard within a limited period.
No, the Supreme Court was hearing it on its own.
Hearing it on its own, but Supreme Court then formed the opinion that no, since it is pending before a special bench, a reference is pending, we'll wait for that. Let that be decided, and then we'll decide. So it's a passing game now. It has been buck. We take the buck.
Buck is on
Yeah,
your lordship.
on us.
It's a very
So that time is over already. So we'll fix a short date. Then
very
formally start your arguments. Something, say something at least, and we'll ask you
Flowers,
presence here. Yes, and just we'll request you to come, all of you to come prepared. Whoever appears, come prepared with the. Yes, Andaman is there. Andaman is there. Yes, you are there. Mr. Kormakar, you are
the respondents.
For the respondents. So they are there.
মানে রেসপন্ডেন্টটা কি
Union of India.
They were to
Andaman Nicobar Administration, Lordship.
Administration.
The administration was to start the submission because they were, my lord, showing the documents of how Bengal Agra Assam Civil Code
Yes,
did not apply.
Yes, Mr. Kormakar, you just then start your arguments and we'll request all of you to come prepared with brief written notes of arguments on the next date so that you can argue within the framework of that and we can conclude.
Lordship.
Because my lord Justice Bharadwaj's judgment, which was deferred with by your lordship, my lord, probably didn't take into account the documents, my lord, which were given, my lord, by the
Those were not placed before his lordship.
It was not placed before your lordship.
Those were not placed
My
before
lord,
his lordship.
they've been placed I think
Yes, sir, we also think so.
Because Justice
Justice Bharadwaj appellate side rules.
Yes.
Appellate side rules, which is
Appellate side rules, if
maybe
it
not
applies,
applicable.
not applicable here.
But that was
That's
not
the
pointed out to
only-
his lordship when his lordship's judgment,
Absolutely.
which was I had the advantage of those documents actually.
Yes, my lord had the advantage.
which was also before us in that
No,
litigation
anything which goes against me, my lord, it comes very nicely, my lord,
on the record.
on record.
So you are the one who you have lost to Justice Bhattacharya.
Always.
Not
That's
always.
all right, not always. Right.
Most of them.
Most of them.
So who is your other side who was successful?
Mr.
No, Mr. Shatadru Chakraborty was then. Now Mr. Kormakar is.
Lordship.
Yes, Mr. Kormakar, you can start your arguments today. We'll hear.
Before Justice Bharadwaj, my lord, I can't even open my mind.
Administration chillo.
Not private partners.
My lord knows what I'm talking about.
আরেকজন কে আছে সেটা তো জানি না।
It's starting.
এটা শতরূপ ব্যানার্জি is there না?
The other one, other matter. Where who appeared before Justice Bharadwaj.
You can start hearing Mr. Kormakar. So
Yes,
that's
yes,
something.
absolutely.
Yes.
Lordship, actually, last date yesterday, I have been assigned by the Andaman Administration, Lordship. Yesterday, I have received the brief regarding pecuniary jurisdiction regarding court fees. For that reason, it was referred to the larger bench.
পরে শুক্রবার রাখি পরে শুক্রবার থাকবো না ভোপাল যেতে হবে তারপরে শুক্রবার তাহলে করছি so we'll keep it on 28th.
Lordship.
You have-
Just yesterday, I have received, I have been assigned, Lordship.
Mr. Chatterjee, please ensure that a notice is given to Mr. Shatru
I'll
Banerjee's
speak to him
junior, whoever-
personally. And he is in the bar library, my lord, he can go and
I will inform.
whatever.
All the learned advocates who appear from the private parties have to come before us and advance their arguments, and Mr. Karmakar will speak on behalf of the.
because Mr. Shatru Banerjee is still adamant that that ratio was correct because I had a talk to him.
Justice Bharadwaj.
Yes. But
So
let
then
him
we should
come up.
we must
Definitely hear him.
Must hear him.
Who was successful in before
Mr.
Justice
Shatru
Bhattacharya?
No,
Before Shatadru, Mr. Shatadru.
against.
The administration was successful.
Oh,
The
before
problem
Justice
is, my lord, what happened in the main matter we won. So they have lost their interest, my lord, before your lordship. In the main matter, your lordship sent
We'll
it back
just
to
say-
the district judge.
Yes.
We won there.
Oh, there is that
disposed of.
এই পয়েন্টটা তো decide করতে
পয়েন্টটা
হবে।
তো
এটা রেফারেন্স তো এটা we are hearing a reference.
Prediction regarding court fee, that point has to be
The
decided.
reference whether it will be heard by the
It's a
not court fee, not court fee, the pecuniary jurisdiction.
Jurisdiction,
Since
lordship.
স্যার বলে দিয়েছি since all the হুকিম বলছে court fee জানি না হ্যাঁ
No, reference টাই তো
reference
question.
is the question reference is the
that was framed by Justice Bhattacharya my lord in that judgment.
এটা আছে
little did I know that I remember
No, my lord, earlier
that
I
had
was
to be referred otherwise Justice Bhattacharya's order was placed at the last minute.
earlier also, my lord, it was always the deferring judges and another judge, my lord, used to be.
Yes, generally what we evolved our practice that it is just given to the third judge and he or she hears it and
Yes.
but now
সুপ্রিম কোর্টে শেষ হবে পরে চুপচাপ থেকে এই করে দেয় we are reviewing বলে অন্য কোথাও পাঠিয়ে দেয়
The my lord remembers that one of the judgments which I won before your lordship, that Deepak Polymer's judgment.
Yes.
It was sent to the larger bench by Justice Krishna Rao. The other, we were not even heard. And my lord, the referee court,
since all the private parties তাই বলে দিচ্ছি।
আমার মনে হয়
since all the private parties are not represented today comma let the matter stand adjourned till November 28 2025 কোটায় রাখবো
তিনটেই থাক
তিনটে
if it's on a Friday, then your lordship would hear it for half an hour.
হবে তাহলে কি দুটোতেই রাখবো না দুটোই করে দিই না দুটোই করে দিই হ্যাঁ হ্যাঁ to be taken up at 2 p.m.
Revision এ 3 দিন হয়।
For some next para learn it
কি
Revision এ 3 দিন হয়।
ও আমাকে বলছে
A revisional court is functioning only for 3 days in a week.
that has original side এত বলো আমি আবার কি
যে পর্যন্ত বললাম ওটা থাকবে learned counsel for the parties are requested to file their written notes of arguments and advance brief oral arguments if any on the returnable date. We are not putting anything on record but please try to intimate the other side also.
I'll do that. I'll do that. Certainly do that.
So we'll sit next on 28th at 2 p.m. Let's
Friday week.
we'll conclude on that. Did Mr. Kormakar please get prepared? It's not on court fees at all. It's on pecuniary jurisdiction.
Pecuniary jurisdiction, lordship. My appearance may be made today, lordship.
No. Only except that we'll do everything.
Lordship, much obliged, lordship.
Give your appearance in the inbox.
Lordship. Nice.
Yes.
My lord, one indulgence, my lord, may I be allowed to permit of mentioning?
No mentioning at this. I am only here to take up this matter.
My lord, Lordship was pleased. I beg to represent the sole contemner, my lord.
Yes, yes.
On 3rd of
What was the nature of the contempt, Miss Patra?
no, there was, my lord,
Order was not complied with lordship.
Order was
subsequent-
to
consider.
illegal encroachment to
Yes,
take
lord.
steps.
If-
No,
if-
consider. Page
that-
13, my lord, kindly see page 13 of the
Means that
contempt application.
The
Just
necessary
check it.
action in due course of law on such course, lordship.
So what is your alleged? What is the alleged contempt? That they are not doing anything.
No,
Yes, lord.
contempt is that only one notice was issued, that is at page 20.
Thereafter, you are
no
not
action
doing
taken. My lord,
Subsequently, joint inquiry was held.
my lord,
as per
compliance
the
done, lordship.
Later, lordship, on 20th August 24, and on the basis of joint
In
inquiry.
fact, Ms. Patra, when you moved the matter, I was in doubt whether there is contempt or not because they have issued a notice. But then we thought that we would not monitor, but we see actually whether that was just an eyewash or they're actually taking any steps. We cannot
Taking
conduct or
steps.
monitor the subsequent step.
Conduct is lordship as I was lordship.
Let us see.
Previous-
Let us see what they have done.
I'm showing lordship. On
It's between us now, the contempt and the court. Yes. What have you done?
Lordship, may I respectfully hand over me the compliance report, lordship. Compliance.
So you had to give an opportunity of hearing to all concerned.
Yes.
Decide it.
It is done,
And
my
then
lord.
if prima facie satisfied, then you are to initiate steps.
Already taken and
You have given a
party-
hearing to them.
Yes, 10(1)(2)(3). It is a action under Bengal Highways Act. So 10(1) section 10 subsection 1, 2, and 3 are to be undertaken. So he has undertaken.
You have been given a hearing.
Yes. Now
Yes,
agreed
sir.
party has gone for appeal pending.
Appeal pen.
The aggrieved party means you have taken a decision also.
Already the contemner is supposed to take a decision under section 10. He has taken.
Where is that decision?
My lord, may I straight away take your lordship, my lord, to my lord, page 26, my lord, of the compliance report, lordship.
Lordship, a copy of comprehensive report to be supplied to me.
Compliance report, give a copy to her.
Yes, certainly,
She also
certainly
is required to. Otherwise, how can?
This photo. 26.
So here private respondent has been held. Yes, he is an encroacher, Shiraj
Yes, you directed removal also.
Shiraj Ali, and thereafter after getting this 10-3
Ms. Patra, please come to page 26 of that. It
Yes,
will be
lord.
clear to you.
They are encroaching.
and page 27,
They
this
are
guy
all
has
lost.
preferred appeal. Appeal date was, so mean that is the next.
This is sufficient compliance.
Yes, lordship.
More than compliance. The
Lord-
smile on your face is very clear.
Yes, lordship, that is true, lordship. But my submission, only submission, lordship, on 7th August 24 for conducting an joint inquiry, lordship. Subsequently, lordship, they have again issued notice for joint inquiry, lordship.
That is beyond the scope of the contempt.
Yes, lordship, I know,
The
lordship.
present.
In this way, lordship, they are
Will
taking
cost
the
to the rule. Why he was not
And
present
in
on
the
that.
appeal, lordship, also the appellant not praised for time. But the authority concern also in
The present
just
contempt
that-
application
Will cost
arises.
to the rule. Why your lordship was compelled to issue
The
a rule
present
against him.
contempt application arises out
I
of.
filed this lordship.
What is this?
Cost to the rule. Why he was, your lordship was compelled to issue a contempt where he was not present on the date of call.
Yes, what is that?
My lord, reason is para 7, my lord, kindly. He has tendered and he is please come.
What was he doing then?
No, he has shot off the letter after getting the order. He has sent the matter to the LR, legal remembrance. So process for engagement of
Very
lawyer, my lord, was the issue. my
And
lord.
an affidavit showing cause for the absence of the alleged contemner on the previous date is filed today. First of it is evident therefrom that the alleged contemner had referred the matter to the legal remembrancer where it was pending for appointing an advocate. Push up as such, the court finds from the said explanation that it is sufficient to explain away the absence of the alleged contemner on the previous date when the matter was called on. Push up such cause is accordingly accepted. So next para, an affidavit of compliance is also filed today on behalf of the alleged contemner. Push up the order, from which the present contempt application arises was passed by this court.
Page 1-3 of the May contempt application. 26th April 2023. 26th April
In
2023.
WPA 2373 of 2022 on April 26, 2023. Push up. Thereby, the alleged contemner was inter alia directed to consider the representation of the writ petitioner as expeditiously as possible and in accordance with law, comma, upon giving an opportunity of hearing to all concerned, including the writ petitioner, positively within 6 weeks from the date of communication of the order, comma, if prima facie satisfied that there is an illegal encroachment, comma, to initiate necessary action in due course of law on such score. Push up from the affidavit of compliance filed today, comma, it is seen that in compliance of the said order, comma, a hearing was given to the interested parties, and video order number 2 dated September 16, 2025, in case number Miss MISC stroke SDK stroke 26 stroke 2025, comma, the alleged contemner had come to the conclusion that there was an illegal encroachment on the disputed property, and within the contemplation of section 10 within bracket 3 of the West Bengal Highway Act, comma, 1964, comma, had also passed necessary direction to recover possession and removal of encroachment of the subject PW land. So for such purpose, comma, the BA Block Land and Land Reforms Officer, comma, Shagor, was also directed by the alleged contemner to assist in the process by clearly demarcating the occupied PWD land at the field. It also transpires from Annexure K to the affidavit of compliance that subsequently an appeal has been preferred against the said writ petition or appeal.
Writ petition.
Writ petition has been preferred against the said.
From this 10-3 order.
Oh, from the 10. An appeal has been preferred against the said order dated September 16, 2025. Pushed up next para. Thus, comma, it is evident that substantial compliance of the order of this court has been done by the alleged contemner by giving adequate hearing and adjudicating the matter on merits and taking appropriate steps for removal of the encroachment. Push up next para. However, comma, the alleged contemner cannot be blamed, comma, since an appeal is pending against his order and his hands are tied at present. Pushed up. In view of the above, comma, this court is of the opinion that no act of contempt subsists. Pushed up. Accordingly, WPCRC 143 of 2025 is discharged. Pushed up. CPA 983 of 2025 stands disposed of accordingly. All further personal appearance of, needless to say, comma, all further personal appearance of the alleged contemner is dismissed.
Lordship,
Thank you.
one guideline should be provided, Lordship. The appeal should be disposed as expeditiously as
Why don't you pass an order in the appeal?
Relatedly, they have complied with your Lordship's solemn order, Lordship.
They waited for 2 days. They had to come and wait for throughout the day for that.
Yes.
That is sufficient punishment.
I was also there, Lordship.
Lordship, happy weekend.